Court does call the case People versus Anthony Reeves.
Your Honor, Raymond Cook.
Yeah, or Alan can get it. I'm sorry, I didn't mean to.
Yeah, Robert, go after Anthony Reeves. Anthony, would you state your name for the record?
Yes, my name is Anthony Lamar Reeves.
Thank you, sir.
Judge, I don't have all the discovery yet. I should have it this week. Hopefully I can arrange a visit with Mr. Reed in Lapeer, the correction facility. Could we adjourn? Is it possible to adjourn this out about 3 weeks?
I want to adjourn.
I'm sorry?
I don't want an adjourning. I want to go for a dismissal.
You want
Want to do what? It can't be dismissed at this point, sir.
You say it can't?
It cannot, but your attorney is indicating he doesn't have all the discovery to be able to talk about the case with you.
Well, I ain't got a chance to can I
Okay.
get like a second to talk to the attorney before y'all adjourn? Because I don't really want an adjournment to 3 weeks.
Okay.
Mr. Reeves, if you would let me adjourn it maybe 2 weeks, I could hopefully set a visit for you and get you to discovery. I know you're anxious to deal with this, but you and I need to talk about the case.
How about 1 week, man?
Well, I can't do 1 week. This isn't a negotiation, really. I can't do 1 week. The shortest period is 2 weeks because we have to do a video writ for you. But that's the best. If you're looking to speed this up, that's the best we can do.
All right.
Probable cause conference, May 7th, 2026, 9 a.m. Beth.
Thanks.
Court calls the case People versus Terreno Rogers.
Your Honor, Raymond Cook for the people.
Terreno Rogers, Your Honor.
Assistant Public Defender Davi Leba on behalf of Mr. Rogers.
Mr. Rogers, state your name again, sir.
Terreno Smalley Rogers, Your Honor.
Thank you, sir.
Your Honor, I'm going requesting adjournment. I have not been able to meet with Mr. Rogers. However, I do have that set up for tomorrow.
You what?
I do have that set up for tomorrow.
Tomorrow you're going to meet with him?
Yes,
So 2 weeks would be good.
that'd be perfect, Your Honor. Thank you.
7, 2026, 9 a.m. Bond continue. Court does call the case of the People versus Evan Sherbert.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Davi Leba on behalf of Sherbert.
Sherbert, can you state your name, please?
Again, Evan Sherman.
All right, I have before me a plea form. Is that what we're doing today?
It is, Your Honor.
Plea form indicates that the defendant will be pleading to the stated count to a receipt of a stolen property, 200 to 1,000. That's a 1-year misdemeanor. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Correct, Your Honor.
All right. Sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name, please.
Evan Sherman.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of receipt and concealment of stolen property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
Still wish to plead guilty?
I couldn't hear you. I'm sorry.
You still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Yes.
I didn't hear you, sir.
I couldn't hear you. I'm sorry.
Okay. To that charge, how do you plead?
Guilty, Your Honor.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or had one signed on your behalf. Is that correct, sir?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
I do not, Your Honor.
You understand that you're waiving all those rights, including your trial rights, which are contained in paragraph 5.
Yes, Your Honor.
Understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will,
Yes, I am.
and because you believe that you are indeed guilty?
Yes, Your Honor.
September 3rd, 2022, at the location of 9429 Main Street in Northfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty of this offense?
I went to the storage locker and taken some items. Brought them back home.
You are echoing there. So you rented the storage locker. Did you have stolen items in that storage locker?
They were at my house. From the storage
So
locker.
at some point, you came into possession of stolen property.
Yes, Your Honor.
Is that correct?
They were found at my
All
house.
right. And you knew that it was stolen.
Yes.
All right. And you tried to conceal the whereabouts of that stolen property from its rightful owner and or authorities. Is that correct, sir?
Yes, Your Honor.
All right. And was the value of the property that you were concealing, was that in excess of $200?
I believe so, yes, Your Honor.
All right. Counsel, you'd stipulate to the value being over two.
Yes, Your Honor.
Yes, Your Honor.
All right. Sir, I do have to advise you that if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Absolutely, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
May 18th at 9 a.m.
May 18th, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will
Thank
continue.
you.
Thank you, sir.
Thank you.
Court does call the case of the people versus Derek Braddock.
I am here.
Half the people.
Assistant Public Defender Davey Lieb on behalf of Ms. Braddock, and I do have a green sheet.
Ms. Braddock, did you state your name?
Yes, my name is Derek Braddock.
Do you have a camera, please, ma'am?
No, my camera just currently broke. My son just currently broke it. I mean, my back camera works.
I'm going to adjourn it this time, but if you don't get a camera fix, you can't appear by Zoom. You got to come down to the courthouse. You understand that?
I understand, yes.
You have not received discovery. Is that the issue?
I have received it as of this morning.
That's part.
I received it this morning.
Got it this morning.
Yeah.
Okay. Probable cause conference will be adjourned to May 14th, 2026, 9 a.m.
Thank you.
Bond here.
Thank you.
Thank you.
You're welcome.
Court does call the case people versus Jason Maples.
Your Honor, reading book of the people.
Morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Maples. Mr. Maples is approaching. Would you please state your name for the record, sir?
Jason Gary Maples.
Your Honor, this morning we have been able to finalize a resolution for a plea agreement in this matter, which would allow Mr. Maples to continue in the felony recovery treatment court. We just got the information moments ago that it would be that the plea agreement we are negotiating is appropriate. So we're asking for an adjournment in order to formalize it in writing. There is also a stipulated order for Mr. Maples to be released.
All of that correct?
Yeah, Your Honor.
So what I will do is, in fact, he's in custody, I'll adjourn it out 1 week to 30th, April 30th, 2020.
Thank
Bond will continue. Thank you. Court recalls the case of the People versus Derek Stewart.
Again, Your Honor, Raymond Cook for the people.
Warner, Jordan Gaines, the public defender, represent court.
Mr. Derek
Mr. Stewart? Okay, thank you, sir. I now have this. report. Do the people have any additional evidence?
No, Your Honor, we would stipulate to the report.
We would stipulate to the report as well. I also believe I submitted a proposed order, but
Yes, ma'am. The court, in reviewing the report, and that being the evidence, it would find that at this time, the defendant is competent to stand trial. Specifically, that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I have signed the order. What would you like this set for?
we would like to set up for a preliminary exam.
He is there, sir.
Yes, that is correct.
What is my 3-week date? Say,
Grateful.
is all discovery complete, Ms. Gaines?
That is my understanding.
And would the people have their witnesses available May 12th?
Is that 3 weeks out, Your Honor?
That is 3
That should work. We'll do our best.
All right. Preliminary examination in person, May 12th, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you. Court does call the case, People versus Jenny Liu. I'm sorry.
Your Honor, Keith Clark. Oh, there we are. Your Honor, Keith Clark, Assistant Attorney General on behalf of the people.
Good morning.
Good morning, Your Honor.
Freddie Judge Torsia, Assistant Public Defender on behalf of Ms. Jenny Lewis, who should be present on Zoom, Your Honor.
You have her? You're not have her.
Your Honor, my office did speak to her yesterday. She indicated she'd be here. I do not know why she's not present. For the record, I'm pushing adjournment, but I do not know where she is.
You're asking for an adjournment. You don't know where she is.
No, Judge.
Go ahead.
Your Honor, we did receive information. I shared it with Defense Counsel yesterday that Miss Liu, after she was given personal bond, took a flight and left the country. Or not left the country, I'm sorry, left the state. She sent what's called a JPay message to a fellow prisoner, or who was a fellow prisoner at the Department of Corrections. She was hopping on a plane and leaving. I can provide that to the court. We have prepared a protective order. Some of the information in this, some of the discovery in this case would be a threat to community safety or to the safety of the prison. So there is a protective order. Hopefully, counsel has a copy that the court can sign, and when the court signs the protective order, I will provide all the discovery to the defense.
I'm sure we have it in our file, Judge. I can print that out and give it to the.
Okay, you can give it to, say, I understand. And I would sign that protective order, but her not being when the representations, what is the bench warrant for the defense press time because it, but the court is gonna, that bench warrant will issue no bond.
Thank you, Judge.
Thank you, Your Honor. And Your Honor, I'm sorry, the court issued the bench warrant, and the bench warrant was for no bond.
No bond,
Full
sir.
arraignment. Thank you, Your Honor.
Thank you.
Bond.
Yes. And then immediately. That warrant will issue immediately. Court does call the case of the People versus Abdurrahman. 2 cases.
Jacob Kennedy for the people, Your Honor.
Good morning, Your Honor. I'm with on behalf of Mr. Bashir. Your name, please.
Your name, sir?
Mom Bashir.
Arrest. Ask the court to please set these for exam. Discovery is complete.
Do people have their witnesses available? We're on the fifth, correct? Would you have their witnesses available the fifth?
Go one additional week, these are rather old cases, and given the length of time that's passed since then, I likely will need to see a new officer charged for these matters. I just sent it out.
Is there gonna be any objection to that?
Yes, and I would just leave it to the court and note the cases are old.
All right. You good? All right. We're tough around. Anna tripped you. No, I think so too. I'm gonna file charges. All right, you want? Is he in custody on anything else? And the people want the additional time because of the age of the case. Gotta get new.
That's correct. 1 7 years old, 1 6 years old. Reason that they are so old.
Noting the objection, but also noting that the defendant. That the reason that people have to do what they are doing is because of the defendant's failure to appear. I will give that additional week. I will set these. For preliminary examination. Discovery being complete. I'll set it for May 12th, 2026, 9 AM on both cases. All right, bond will continue.
Which judge is that?
Oh, before Judge, I'm sorry. Before Judge Washington. Thank you. Court does call the case, People versus Darius Cadell.
Your Honor, reading code for the people.
Got ready, Your Honor. Good morning to you. Good to see you, Matthew Mansour, on behalf of Mr. Cadell, who's approaching. To my right. Mr. Cadell, can you please state your name for judge since Darius Cadell? Your Honor, I have two things for you. I have a green sheet and a bond filing. For
Yeah, you can get that up to me at some point.
okay, thank you.
Thank you. You're asking for an adjournment.
Yes, please, Your Honor. I'm going to start the negotiation process. I just got the discovery, the media discovery yesterday, so it's about done.
Why hasn't he gone over to community correction?
Your Honor, I've talked to him about that. And him and his mother, he's had transportation issues. That is not going to happen anymore. He understands.
I know that.
Because I let him know how serious these matters are, that this court is not one to play around with. And he knows that he could potentially be incarcerated for not drug and alcohol testing. Something like this, it can be fixed and it will be fixed. If you just allow, he will test today, Your Honor.
Gonna test clean
Sure.
for everything?
Yeah, yes, sir. Even marijuana? Your Honor, oh, 1 second, Your Honor, please.
Well, May 12th, the last year meeting was Washington.
Last time I did it was Washington, Saturday. Your Honor, to be candid with you, to be
Really?
honest with you, of course.
So what changed that?
Just, you know,
Oh, go ahead. I'm listening.
you gotta be honest and upfront with you, Your Honor.
Really?
I know how it is. Yes, yeah.
Oh, that's the problem.
Marijuana traces might appear, but he knows.
Marijuana traces might appear.
Yeah.
What's that mean?
He used marijuana a few weeks ago. I don't know if it's in there or not, but just letting you know, just being honest with you. And he knows he'll
So he got out of jail. He's not supposed to be using any drugs. Does he have a medical marijuana card?
know, but he will not use anymore. I didn't use it like the day before. It was before, Your Honor.
Pardon?
It was before he used marijuana before he got arrested. I didn't use it after. And we can track the level. He's gonna comply. I know he will.
I don't know that you can make that representation that you know that he will, because he's not thus far.
I have faith.
Okay.
Yes.
May. All right, record should reflect we had a bench conference in this. And I'll just put it this way, there is, while this might seem minor on this case, defendant is also on, and I'm not going to go into detail, but he's on probationary status at the time of this offense. Part of that probation includes that he should not be using drugs, should not be using anything, shouldn't have been using marijuana at that time. So what I will do is give counsel time to check into that and his potential violation of that probation. I'll adjourn this out 1 week to April 30th, 2026, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Court does call the case, People versus Kurt Bushline.
Office for the people.
They may not be able to bring him out.
Morning, Your Honor. Jay Grant Miller, P 58658 on behalf of Mr. Bushline, who approaches from the back. Please state your name, sir.
Bushland.
I have before me a plea form that indicates the defendant will be pleading to an added count 2 of use of cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There is a sentence agreement to credit for time served and fines and costs. That's the court's full understanding of the agreement.
Correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Right in. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Kurt Bushline.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th.
Okay.
Yes, understand that? Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form or had one signed on your behalf. Is that correct, sir? Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And because you believe that you are indeed guilty?
Yes, sir.
September 22nd, 2026, at the location of 100 South 4th Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession? Had you used it?
Yes, sir.
Did you know what you were using was cocaine? All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in court rules, that would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir? Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule?
People are satisfied. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be May 8th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Plea.
Good morning,
And
Your
your-
Honor. Wendy Barnwell, P42505. I believe you may have called Andrea Clay. I only heard.
Yes, that is the one I called.
Okay. Yes, thank you, Judge.
She here? Andrea Clay, she is not here, Miss Barnwell. Much like you. No, I'm kidding. Because you won't come see me. It's okay. My feelings aren't hurt. You have any notion of her whereabouts?
Judge, I talked to her godmother this morning, and I had heard from her godmother had responded. Now, let me say this. I had sent her a text before I saw, at 1 o'clock this morning, I saw that the JA had sent me an email saying that she has to be here physically. She cannot come on Zoom. When I initially sent a text message, I told her she may come in person. I used the word may, but I also gave her the Zoom number, assuming, because I accepted the case recently and I asked for Zoom. So that has happened where I did. But then this morning, when I saw it, I sent her the text immediately. Then this morning I called her godmother and she had enough time to get there. I called early in the morning.
Okay.
So I'd ask that we hold off, but it's within your discretion, Judge.
I know. Thank you. Thank you, though, for letting me know that. Go ahead.
I'm aware that there's a community corrections violation as well. I request bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Thank you, Miss Barnwell. And at some point, you're going to come back down and actually see us in person, aren't you?
Yes, I had a trial in Ann Arbor that took up a lot of time, and I wasn't taking cases while preparing because it was a big one.
Got it. Okay, well, we'll see you soon.
All right. All right, thank you. Have a good day, everybody.
Court calls case, People State of Michigan versus Michael Burge.
People, Your Honor. Courtney, Assistant Public Defender representing Mr. Burge, who will be approaching. Your Honor, we are requesting an adjournment for ongoing negotiations. You have a blank sheet.
Two weeks.
Yes, please.
Oh, you just find that. All right, probable cause conference will be adjourned May 7th, 2026, 9 a.m. Bond continue.
Thank you.
Yeah.
Thank you, Mr. Byrd.
Court does call the cases of the people versus Edward Eugene Harris.
Under Michigan Court 8.120. And the supervision of Assistant Prosecuting Attorney Ellie.
Finally, she's letting you do stuff, right? No. It's your last day? She's finally letting you do something, but now it's your last day. Good job, Zenda. Well, it's been a pleasure having you before the court, I will say that. And permission to practice is granted.
Good morning, Your Honor. Jonathan Sachs for Mr. Harris in his case ending in 1250.
Portia Feaster on the remaining cases, Your Honor.
That's right. Is he present?
On Zoom there, Judge.
Yes, Your Honor, he is.
Mr. Harris, can you state your name, please?
Edward Harris.
What do we do?
Your Honor, we're continuing negotiations. We're hoping to have a good resolution here that should be able to take up all three of his cases.
Yes, Judge, that's accurate. Would be asked for adjournment.
All right.
We request 3 weeks.
Hearing no objection, I'll set it. I got it. Thank you, though, for putting your nose in it. Be adjourned to May 14th, 2026, 9 a.m. Pod continued.
Judge.
Thank you, Your Honor. Mr. Harris.
Court does call the case people versus Deanne Bird.
We have the people.
Hello.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Byrd. would you
Hello,
please
good morning. Morning, your name? John Bird. Thank you. What are we doing?
Your Honor, I did reach out to Ms. Zinda because we did not receive discovery in this matter. I have spoken with Mr. Byrd, who states this is a reauthorization case. So I did, both are. So I did go back to look through our file and I cannot confirm for one of the cases that we did represent him. I believe it's my understanding from him that we did, but in terms of looking through the file and matching the dates that these have alleged to have occurred. So that's the first thing.
Just so I'm clear, what you're telling me is that you may not have discovery because you had a bit of a record on one of these.
Your Honor, I'll make this easier. It was resent yesterday for both files. What was I didn't realize it was the same in evidence items. We did a new meeting notice, so it should be released yesterday.
Got it. Okay.
Still not in my file as of last night when we met. I will check again. I have not checked this morning. So I am asking for some time for that, but I would also like to address bond. And if I could have 1 moment.
So if you're gonna get the discovery, here's what I want to also make sure of. I don't mind adjourning it out, doing that, but I want to make sure if Mr. Bird's indicating that on the previous ones, that the public defender represented, that there's not going to be an issue. What I would like not to run into, if we can avoid it, is all of a sudden you're here on both cases, but now you have a conflict and then it's put out and then
yes,
it's further delayed. But we don't know that yet. Yes.
I do not believe that we have a conflict just based on my review of our representation of him in the past.
Got it.
And that it's the same complainant.
Okay.
Currently, or pardon me, we very recently represented him on a probation violation involving the same person as that.
Okay. Then I'll adjourn this out to May 7th.
I was going to say, could we have a shorter period of time? And I will explain that in part. Even
go ahead.
Even just a week would be fine. That is because Mr. Bird is the complainant in a matter involving this same complaining witness. This is a 2024 case. There is currently a matter where he is the victim, and this morning I was able to find that case and make copies of the register of actions for both Your Honor and the prosecutor. And he has been attending all of those court dates, but there is a concern that part of this case was dismissed in 2024. And I was able to confirm, as my client told me, that just before the meeting with the friend of the court in their divorce / custody proceeding, that the complainant came to the Washtenaw County Prosecutor's Office almost 2 years later, asking to have the matter reauthorized. As it states in the report, that does not mean it's not any less serious, but it is an interesting state of affairs. And he has a pretrial on the matter where he's the victim. He's been attending each of the case, all of the hearings.
That case.
That is in Wayne County, and that is on May 8th. And like I said, I was able to print that out for Your Honor and the prosecutor this morning when I found that.
And Your Honor, I want to say for the record, I spoke with the victim myself before reauthorizing this case, and she indicated to us that at the time these cases were dismissed, she was extremely terrified with the defendant and was not comfortable proceeding. She now has a better support system around her, and he had continued to harass her in the time since these cases were dismissed, and now she felt more comfortable and safe proceeding, and that is why these cases are now back before the court.
I also have, and I did not, because I'm not trying to retry the custody case, but I do have the recommendation where she speaks about what a great father he is and all of those things. So I wanted to.
It's terrible maid.
You
right?
Can be.
That's it. So I don't know what that has to do with it.
But
I'm not a family court, so I don't know what
Yes.
that means.
But my point being is that I'm only trying to address these as far as bond and to have a court date next week so that he will be available to go to the pretrial hearing for the case where she hit him with her car.
Allegedly.
Allegedly.
Thank you.
Yes, yeah.
So
Definitely.
that's set for the A.
That is set for the 8th. So if we could have a 1-week adjournment.
Any objection to it?
Mayor, the discovery was sent yesterday, so we should have everything.
We'll adjourn it 1 week out to the 30th.
And Your Honor, we would ask that the court, considering how old this case is, and that in terms of since that case was dismissed in 2024, there have not been any allegations or cases as far as Mr. Byrd. The only cases have been I believe there are 2, but definitely this one pending, where Mr. Byrd is allegedly the victim. And so with that, I believe that he can abide by any orders, no contact orders, or whatever the court would say would be appropriate, so that he can continue to not only pursue this case, but also his rights as related to being a victim in the other case. And so we're asking for personal recognizance.
I'm gonna object. This is 2 cases of aggravated stalking. In these cases, it includes threats to the victim that include the defendant texting her, "If I see you in Ipsy, I'm walking you, bitch. Don't be home. You need to learn to keep my name out of your mouth." That he will. Everyone in the victim's car with her will get hit. And then this case came back to us with the victim because she informed us, and this was in a Washington measures report that is going to be edited with a later report, in which he was still continuing to harass her, showing up to her unit unannounced and calling her, looking at her social media posts. And that is why this case is dead. So I do have concerns for persons, given that even when the issues were dismissed, that pattern of harassment did continue. And I have concerns for her safety. Given
There's no allegations of any of those things since 2024. These are allegations from that case from 2024. We have not had any cases
No, we're not.
come forth. Pardon me?
That's not what I'm hearing.
December of 2025, that wasn't a different case that I somehow didn't get added onto this one as a related report. That includes allegations of him coming to our unit in 2025, December of 2025, and continuing to harass her. So I will add that and get that sentence in today.
Your Honor, that was after those other matters were dismissed and there continue to be parents together. But if the court implements an order, a no contact order, then he will abide by that order.
This, since I'm adjourning it out the 1 week. 30th. I'll just adjourn it out there. At this point, I'm going to deny the motion for bond reduction or modification of bond. Let you take a look at that other report, see whether or not that other report is relevant to your bond argument.
Thank you.
Thank you. Court calls the case, People versus Jeremy Shue.
As false for the people.
Good morning, Your Honor. Jonathan Sachs for Mr. Shue.
That's the one.
I believe he is on Zoom.
Have it. Oh, he's the scales of justice. Mr. Shue, really? Okay. Jeremy. I'll pass it. We'll see if he'll show up.
Thanks, Your Honor. I'll get in touch with him right away.
Court does call the case, People versus Antonio Guyton. Oh, they're not up yet. Sort of pass that matter briefly. Let me. Court does call the case of the People versus Antoine Thomas.
Albert L for Mr. Thomas, who should be logging in Zoom. I know he's having some trouble earlier. Judge, can we pass the matter? I know he's been trying to log in, but I guess he was having some trouble.
I'm here, just trying to figure out how to turn on camera. Can you hear me now?
I can hear you. Can't see you.
Okay, let me see.
Oh, that's Jeremy.
No, it says Antoine Thomas was.
That wasn't Mr. Shue. I see Mr. Shue on the screen. That wasn't Mr. Shue. That was Mr. Thomas.
Hey. Can you guys see me now?
We can see you.
And Antoine, if you could please state your name for the record.
Antoine Thomas.
Your Honor, your Honor should be in possession of.
I have a plea sheet in front of me that defendant is going to be guilty of a controlled substance, a 1-year offense. On his successful plea to that charge, count 1 would be dismissed. I also have a sentencing agreement between the parties. Prosecutors deferred sentencing. That's the court's full understanding of the agreement.
That's correct, Your Honor. Thank you.
Yes, Judge, that's correct.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Antoine Thomas.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of use of, which drug are we talking about? Cocaine?
Yes.
Yes.
Okay. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would sentence before Judge Garwood in the 15th District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up all the rights, particularly the rights under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will,
Yes, I am.
and also because you believe that you're guilty of this offense?
Yes.
September 15, 2025, at the location of Boardwalk Drive, City of Ann Arbor, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, I have.
And did you know what you were using was cocaine?
I was aware. Yes.
Okay. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Absolutely. Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
I am not.
And have I complied with the court rule?
People are satisfied.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
May 12th at 9 a.m.
May 12, 2026, 9 a.m. before Judge Garwood. Bond will
Yes, sir.
continue.
Thank you, Judge. We'll be in touch, Antoine.
Okay. Thank you, Kyle. Have a good day.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Antonio Guyton.
We're getting your honor agreement for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Guyton. You doing some? Your Honor, this morning, Mr. Guyton will waiving the preliminary examination. We've submitted a preliminary examination form waiver.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with counts 2, 3, and 4 follow.
What is?
I'm so sorry, what was that?
What are constant for?
What was that? Those are the misdemeanors.
Okay.
Joy, pardon me. Your Honor, we acknowledge receipt of the information, waive its reading on the record, and at this time, my client wishes to stand mute and have the court enter a not guilty plea in his behalf.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 4 counts. Pre-trial will be set for
May 4th at 1:30 with Judge Hamud.
May 4, 2026, 1:30 before Judge Hamud. Bond will continue.
Your Honor, we have also submitted
I signed it.
wait order. Thank you so much. So he signed the order regarding treatment.
Thank you.
Thank you.
They need to stand. Court recalls case People versus Jeremy Shue.
That's all for the people.
Thank you, Your Honor. Jonathan Sachs for Mr. Shue.
Jeremy Shue.
Now,
Thank
As
you,
soon as
Jeremy.
you called my case last time, it kicked me out of the Zoom hearing, Your Honor. I'm sorry.
It did?
Yes, it did.
I probably did that on purpose. I'm kidding.
At this point, I wouldn't be surprised, but not
And listen to you. Don't even try it, Jeremy. All right. What are we doing?
thanks, Your Honor. This had been adjourned a number of times for Mr. Shue's Court of Appeals pro per motion. That has since been denied. So I'm requesting an adjournment for us to talk about a potential resolution of this case, and then we would combine a misdemeanor case in Judge Wash's courtroom if that comes together.
I don't know what the last part of that meant. How much time did you need?
Could we get that same May 14th date if possible?
Jeremy, I'm going to adjourn your case May 14th, 2026, 9 a.m.
Yes, sir.
All right. All right. Bond will continue. Take care.
Thank you, Judge.
All right, have a good day, sir.
Here. Court calls case People versus Jada Olive.
People.
Good morning, Your Honor. Robert Ellman on behalf of Miss Olive in case number ending in 1321. Your Honor, Mr. Kulavos was here. He is representing Miss Olive on the other case. However, I was informed this morning that he is taking over my case as well. I believe he filed an appearance. He has asked me to stand in on these matters.
Well, he'd have to file a substitution, first of all.
I understand, Your Honor.
Okay.
I'm working with what I have here.
It's pretty much the call of my given day, or any day for me.
So,
All right, so you're looking for an adjournment.
I know that I had Mr. Kulavos fill out a couple of green sheets. I believe you have those in both files.
Should have the green sheets.
Yeah.
Mr. Clovis was here.
Where'd he go?
He indicated. I told him if
He had to go someplace else. The judge would be upset if he didn't go there.
correct,
So what am I supposed to do?
apparently not
I'm-
upset.
I'm kind of inconsiderate judge.
Your Honor, on
I'm
behalf,
have to change that whole.
on behalf of Miss Olive, I'm here and I'm happy to see.
No, I'm not. Miss Allen, you understand, what's his name? Clovis?
Kulavos?
He's gonna be representing you on both matters? Is that your understanding? All right, do you have any, for the purposes of an adjournment today, do you have any objection to Mr. Alman stepping in?
No, sir.
All right, thank you. All right. Did he indicate to you as he headed off to the other judge that he likes more? How much time he'd need?
No, Your Honor, I believe maybe sometime in an early May date, maybe mid-May would be fine. I don't know.
Your Honor, I spoke with Mr. Kulavos this morning, certainly I don't want to put words in my mouth. I think that we're getting pretty close to a waiver being included here between the cities.
Sorry. Are these the only cases holding you, young lady?
Yes, sir.
Are you still being?
That,
Let me double check, and I believe she has
I'm done.
probationary matters.
oh, she's serving time on probation violation. All right, then I'll adjourn it to May 7th.
Thank you, Your Honor.
Both matters. 26:09 a.m. All right.
Thank you, Your Honor. That's it for me. Have a good day. That's it.
Here, nothing. No, I'm kidding.
I could have left with Mr. Kulavos, Your Honor.
Yeah, I got a way of getting you back.
It's good.
But anyway, never mind. All right, thank you. Have a good day. Court does call the case of the people versus Sebastian Phillips.
Anything for the people, Your Honor?
Good morning, Your Honor. Rob J. Columbia. Name Sebastian.
Sebastian.
Judge, I know my client is anxious to get this case going. However, we still don't have the report from.
Pardon?
We don't have the competency report yet, Your Honor.
We did, I have a copy of it, CFP. We got the competency report. He's talking about, I guess.
On this case, I don't have it.
We have an ATO with Darlene O'Brien that he's saying that we could use for competency referral to go to Kalamazoo Psychiatric Hospital until I'm being competent. That's what he was trying to indicate, but
Judge, can we adjourn this out a couple weeks?
can I make a statement?
And I don't have one.
I have it right here. I have a copy of it.
From the forensics?
Yeah, from the forensics. It's to Judge.
Is that the report that says you're incompetent?
Yeah. Well, you're not referring to that?
That we're waiting for you to gain competency. We know about.
No, of the incompetency report.
Yeah.
The other report or a review of that report, correct?
Correct.
Yes.
And that report, Mr. Phillips, you don't have.
I thought, see, he's not being clear and concise with me.
Who's not?
My attorney.
Oh, Mr. Kilowald is one of the most.
I know he's good. I'm just saying that we're having some
clear issues with being clear and concise on the specific.
Well, here, let me be clear and concise. There was a report that found you incompetent.
Right.
I do not have any other follow-up report. Mr. Kennedy has indicated the people do not, and Mr. Kilowalt has indicated he does not
Okay.
follow-up report.
Okay, I wasn't.
So all I can do is adjourn the matter
Oh,
so we can get a follow-up report.
so are you referring to a referral to a CFP facility? Is that what you're?
I'm not referring to anything. The only thing I'm referring to is I don't have a report.
Yeah, so what I'm trying to understand, because I don't understand, is if we have the CFP report, then need an additional document, is what you're saying? In order for me to be
Mr. Phillips, there's a report that says you're incompetent right now, but restorable. We're
Right.
waiting for that. You and I discussed on the matter and the other matter, if you want to go to the psychiatric hospital in Kalamazoo, that if you think that'll help restore you, that we shouldn't confuse the two cases. In this case, Judge Simpson does not have a report that says you're competent. I'm asking this to adjourn this out 30 days.
Yeah, so what I wanted to say is that they the yeah. Would it be IST? Incompetent to stand trial? Would that be an order that needs to be? Because we're trying to figure out if I'm deemed incompetent, where am I going to be? Because they said that they can't. Community mental health said that they can't.
You have to work that through with your attorney. The order finding you incompetent, that has already happened.
Yeah.
I'm just looking for a review of that.
Oh. Oh, sorry.
Mr. Phillips, let's just get the 30-day adjournment. If the judge will grant that, I will deal with the other matter, see if we can get a referral order.
I will adjourn the competence hearing to May 20.
I'm sorry, Judge, what was that?
28th, 2026, 9 a.m. Defendant's bond will hit.
Okay. Thank you, Judge.
Yeah.
I'm gonna explain it.
Oh.
Give me a call.
Okay. Court calls the case People versus Joshua Hillsburg.
People, Your Honor.
Robert, on behalf of Mr. Hillsberg, who is coming out to join us as we speak.
Your name?
Joshua Hillsberg.
All right, what are we doing?
Thank you, Judge. Your Honor, Mr. Hillsberg is being arraigned on an additional charge this afternoon. So we are asking for an adjournment so they can catch up.
One with him. Did we give a date that they're gonna try to set his other cases? We were gonna give them the date. So how much time did you want? You want 2 weeks out or 3?
There is, in relation to that, there's some additional media I'm expecting, along with some supplement reports.
So we got this all.
So it may.
It's very simple. Yeah, I mean.
2 or 3 to work.
I'd ask for the shorter side.
Well, I also want to make sure that you're gonna get the additional media, because otherwise we're gonna get here and then we're gonna ask for an adjournment, but if you want the shortest time, I'll give it to you. Shortest time, May 7th. Hope we have everything. May 7th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Okay.
Court calls case People versus Going Robinson.
Good morning, Your Honor. Assistant Public Defender, Denazra Ikiri Akinlili, on behalf of Mr. Glenn Robinson on the 1556 now.
Morning, Honor. Rob J. Cole. Judge, I have case 2330.
Your name, sir? Owen Robinson. Thank you, sir.
Judge, I met with Ms.
Great to see you, Ms. Eckerman. I was at a conference and somebody asked specifically about you and how you were doing.
Oh. I
I gave them my report.
That's good. Great things, Judge.
Okay.
Judge,
What are we doing?
Mr. Robertson and I met in my office. At this point, he wants to set it for exam.
And on your matter?
The same, Your Honor. We'd like to set it to preliminary exam.
All right, discovery is all complete on both cases.
Yes, Your Honor.
Yes.
Would the people have their witnesses available the 5th? Preliminary examination in this matter will, in both cases, will be set for May 5th, 2026, 9 a.m. before Judge Fresh Hour at 10 a.m. on the 5th.
10 a.m. Okay. Thank you, Your Honor.
Thank you, Judge.
I'll talk to you beforehand, okay? Be good.
Court does call the cases of the Will versus Chidra.
Your Honor, reading.
Assistant Public Defender J. John, on behalf of KG on all matters not ending in 1678, Your Honor.
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji on his other matter. And he is coming from.
He's actually right behind you.
Oh,
Right be. Oh, thank you. All right. Waiving.
Your Honor, yes, he is waiving, and we have an agreement to be placed on the record. And after his waiver of the prelim, we'd like to address bond, please.
And Your Honor, that's accurate. It's a bit of a long agreement, but I guess with counsel's permission, I'll go to a brief version. He's going to be waiving off and on the 3 non-CSC cases. He'll be pleading to misdemeanors under HIDA in circuit court with the idea of being to keep the probation all in one place. On those cases, I'll need Mr. Fenton to outline the plea of release to the CSC matter. Yes, so that's with that matter, Your Honor. Bond over 64 to 1360.
Not a correct statement.
It is, Your Honor.
It is, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand all of these matters. You understand that a preliminary examination is where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand.
You understand that in all of these cases, you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
The people on all of these matters also waive their right to preliminary examination.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on 1, 2, 3. One, 2, 4. Just trying to make sure I have all of the counts. On all 6, 1, 2, 3, 4, 5, 6, 7, 8 felonies, he's waiving and followed by the 1 misdemeanor.
Correct, Your Honor. As to that, we would waive formal reading, stand mute, acknowledge receipt of the information.
Us to Your Honor on case number 1678.
Defendant having waived formal reading, standing mute. On all of the cases, court will enter not guilty plea as to all charges. Pretrial in these matters will be set for
May 12th at 1:30 with Judge Conkey.
May 12, 2026, 1:30 for Judge Conkey. Esteban.
Thank you, Your Honor. Mr. Ikeji has been in, he's now approaching 200 days. The original bond that placed him in jail became reasonable based on mental health issues that culminated in a new arrest upon the same day as an initial release. That obviously was a unfortunate set of circumstances that resulted in a series of mental health evaluations, new treatments, competency and not guilty, but and insanity evaluations. The result of that now is he's been on new medication for a number of months now. Mr. Bellamy and I have both seen he's basically a different person since that started up. The Forensic Center noted the same thing on their evaluation that recommended or that concluded not guilty by reason of insanity. We have confidence now that with home confinement, he's going to do really well. His father is here today. He would stay with his father. His mother could not be here today because of work, but she has been at every other court proceeding. Mr. Ikeji is graduated from New York University. He has no criminal record beyond this series of arrests that were all part of the same connected mental health crisis. He's an extraordinarily promising young man. I look forward to his success down the road. And we're simply asking that close to 200 days is more time of incarceration than he is absolutely going to receive once these pleas are implemented. So we would ask that you consider a shift to home confinement today.
Response from the people.
Your Honor, people are fine. So by fidelity, it's also after the defendant, that condition of defendant's not apply with any worse for CMH as well as in prescribing drugs of medication.
Any other response from the people?
No, Your
No, I would just echo what Mr.
So you have no objection to a PR home confinement in compliance with CMH? All right, I don't have a problem ordering that then if everybody's in agreement. However, I'm going to need an order to that effect.
We'll get that for you, Your Honor.
And it's a home confinement tether, correct?
Yes.
All right. Well, I'll need the order because these files will otherwise be going up and then it'd have to be signed to somebody else, but
We'll get that to you today, Your Honor.
okay, thank you.
Thank you, Judge.
So we'll keep your date. Okay.
Thank you, Your Honor. Stop being like that.
You're gonna have to. Right, you're gonna also have to. Something with this bond order, they're gonna need to prepare an order for me if they're gonna.
Okay.
I need to know that, but I wanted to make sure all this paperwork. And then I don't have. Counsel on these, will prepare them for your signature of the information. However, I do not have all of I only have 2 of the information. So you have to check with my staff to figure out which ones you need to print and get to us.
Yeah, understood. Thank you.
Well,
Thank you.
Yes.
Yeah, good chance.
I'm gonna have this bond continued because
Absolutely.
otherwise,
So before it comes.
yeah, I've got 2 of the information. Court does call the case People versus Diamond White.
People, Your Honor.
Morning, I'm Rob Jacob on behalf of Diamond White. Your Honor,
Diamond White.
Thank you.
Judge, I'm sorry, I have a green sheet. When we adjourn this a couple weeks. Who's the point?
On the other side of this.
Pardon me?
And then I have a few more.
Thank you. I didn't hear, so. All right, you want to do what?
I was just appointed if we could adjourn this a couple weeks. I'd-
Have a green sheet?
Yes,
How much time did you need?
couple weeks.
Probable cause conference will be adjourned May 7, 2026, 9 a.m. Bond,
You're not the same.
thank you.
Sorry, what? Yeah. Yeah. All right, thanks, Judge.
Court calls case People versus Santos Alatif.
Assistant Public Defender Chinazi Carey, I can rule Your Honor on behalf of Mr. Alatif. Mr. Alatif.
Sir, solid T. Thank you.
Your Honor, we are asking that this matter be set for preliminary examination. We'd also like to address a bond request.
I have a bond request.
Your Judge.
He's out.
Yes, we'd like to keep
Okay,
it that one.
messed this up, aren't you?
No,
Would you have all discovery?
To our knowledge, Judge, yes.
People have their witnesses available the fifth?
Try for that date, Your Honor.
Oh, that's, okay. Preliminary examination will be set May fifth, 2026, 9 AM. That is before
Judge Perry.
Judge Perry. Yes, Esteban.
As to bond, Judge, Mr. Alatif indicates that he has a wedding that is scheduled for June the 24th
Not his.
not his wedding, Judge, no.
Nobody needs to be there.
Nobody needs to be there.
It's gonna happen.
Mexico.
Go ahead.
It's in Cancun, Mexico. And yeah,
Go ahead.
so we're asking for permission to allow him to travel for that time period to the
What's the time period?
June the 24th to return on the 30th.
It's a long wedding.
I know, Judge.
Any objection from the people, please? Really? No.
Let's just test and get it down.
I will allow the defendant to travel to Cancun. Those include your travel dates, sir?
Yes, sir.
June 24th to June 30th. He can travel to Mexico.
Thank you.
I would indicate that immediately upon your return, June 30th is the meeting. So you are to report to July 1st, 9 AM to Community Corrections. For take needs. Okay.
All right. No,
All right, thank you.
Panel with an ECG.
Yes, full panel with it.
okay.
We'll prepare that one.
Thank you so much, Judge.
Thank you. Court does call the case, People versus Kelly, Joe, well.
Good morning, Your Honor. Edward Drukas on behalf of the defendant.
Oh, good morning, Mr. Jervis. All right,
Good morning.
your name?
Kelly Group.
All right. You're asking for an adjournment, sir?
Yep, for the purpose stated on the green sheet.
All right. 2 weeks. Will 2 weeks do for you? Or
2 weeks can work. I have the submission form for the recovery court I was going to turn in, but it may take a little longer than 2 weeks.
longer than that? Yeah, okay. Why don't I do the 14th? Let's see where we are, okay?
Sounds good. Thank you, Your Honor.
All right, I'll adjourn to May 14th, ma'am. All right, 9 AM. Bond continued. Thank you. Court calls case, People versus Jennifer Baker.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who appears via Zoom. Ms. Baker, can you please unmute yourself and state your name for the record, please?
Yes, Jennifer Lynn Baker.
Your Honor, I'm just taking a little more time. We're in the middle of negotiations on this.
7th work or the 14th?
7th is just fine.
Adjourn the matter to May 7th,
Thank you.
2026, 9 AM.
Thank you, Your Honor.
Thank you, ma'am.
Thank you.
Court calls case, People versus Connor Kearns.
Then I'm gonna have people, Your Honor.
Morning, Your Honor. Richard Lippin on behalf of the defendant, Mr. Kearns, who's approaching the podium. Your Honor, in regard to the probable cause conference, I spoke with the prosecutor. I believe that we're going to try and resolve this matter by seeing if Mr. Kearns would qualify to get into Veterans Court. He needs to be screened at before it happen. For that reason, I'm asking that we have a new PC for May 21st.
21st, okay, better be. Probable cause conference, I'll adjourn to May 21st, 2026.
Thank you, Your Honor. Now, on a separate matter, Your Honor, I'd like to make an oral motion regarding bond.
No, go ahead.
Your Honor, the court is well versed in this case, having spent an inordinate amount of time on it earlier this week. Mr. Kearns is first time this is his first criminal matter of any sort in his life. He's 31 years old. This has been a sobering experience for him the last 72 hours. I think that he has a greater understanding of the seriousness of the orders of this court. We're asking that the court consider releasing him at this time to home confinement, work, school, court, those types of things. If the court is inclined to give him home confinement, we would also ask that he be allowed to go to the YMCA. He tells me that the victim is not a member of the YMCA, does not belong to that YMCA. And so that would be our prayer, Your Honor.
In Ann Arbor?
Which YMCA? I think in Dexter.
In Dexter.
In Dexter.
Dexter. Response from the people.
I would not have been released on a home confinement with other hours for work and school. Yeah.
All right. What I will do is I will grant defendant's request. I'll reinstate his previous bond amount. He will be released. He will have to report. Actually, I want a GPS on him prior to his release. That would be a home confinement. GPS tether with releases to school and work only, and the YMCA only.
Is that an order that I need to prepare, Your Honor?
We will actually, no, we will prepare. I have the order reinstating his previous bond.
Great.
To the community corrections order, we'll prepare that.
Great. So I don't need to upload any.
No.
Great.
You got it.
Then, Your Honor, if I could just quickly voir dire the defendant for one quick second. What happens if the victim shows up at your house? What do you do?
I call the police.
Okay. What do you do if you see her anywhere?
Call the police.
Okay. You don't speak to her. You don't do anything. You understand?
I understand.
Okay.
You understand, sir, because of what was in this, that includes texting or any communication of any type.
Yes, Your Honor. I understand.
You understand that through no electronic means whatsoever, meaning your use of the internet or anything like that, are you to refer to her in any way? You understand that?
Yes, Your Honor.
And you are not to try to communicate with her in any way. So understand that.
Yes, Your Honor.
You understand that also applies to your family member.
Yes, Your Honor.
And that you would be directing them not to do that.
Yes, Your Honor.
And that if the court were to find that there was that type of third-party communication, you would explain to them that your liberty is in jeopardy. You understand that, sir?
Yes, Your Honor.
All right. Very good.
Thank you very much, Your Honor. Thank you for your time on this matter.
No problem. Thank you, counsel.
Thank you very much.
And counsel on, did he leave already? He bolted. Can you just check? And I need counsel to approach on that last one. Went into a side room.
Looking in front of me.
Court does call the case People versus Maurice Boyd.
Votes for the people.
Assistant Public Defender, Your Honor, on behalf of Mr. Maurice Boyd, it's on Zoom, Judge.
I'm walking to the. Okay. Mr. Boyd, can you stay, please?
Maurice Deshaun Boyd.
Thank you, sir. You're welcome.
Judge, we're asking for an adjournment to put together some mitigation for Mr.
No strict matter. 14/2026.
Thank you, Judge.
Thank you. God bless.
And to you, sir. Court does call the case People versus Jason Banks.
Then we have. Good morning, Your Honor. Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Haidu Banks, who's up
Really?
in the podium.
You were there all morning.
I know it's about time.
There's something gotten up.
I know.
Oh. Don't give you a lot.
Your Honor, I have quite a few cases actually. It's just they're all at the end, toward the end of the alphabet of your block.
Got it. Okay, understood. Your name, sir?
Jason Oscar Haidu Banks.
Thank you.
Your Honor, we're requesting about a 2-week adjournment. Mr. Haidu Banks has informed me that him and his family are working on retaining Allison Krieger, and she just needs a few weeks to get that ironed out, and hopefully she'll be prepared to proceed by the next.
2 weeks, you think?
I believe that should be enough.
Yeah, 10 days or 2 weeks should be good enough, sir.
Okay.
Yes, Your Honor.
So I will adjourn it out to May 7th, 2026, 9 a.m. It's the only adjournment you'll get for that purpose, sir.
Thank you, Your Honor. Much appreciated.
All right.
Your Honor.
I'll go. Court does call the case People versus Glenn Bradford.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Bradford, who approaches with Glenn Bradford.
Do I have before me a plea sheet that indicates that the defendant would be pleading to count 2 violence upon a successful plea to that charge, the 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement to sentence under 7694A.
That's my understanding as well, Your Honor.
All right, very good. Let's have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, but the truth shall be God.
Yes, I do.
State your name.
Glenn Bradford.
Sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. Understand also, sir, that while I'm taking, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B.
Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Your Honor.
Question regarding any of those rights?
None.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead? No. Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're indeed guilty of this offense, sir?
Your Honor.
On date of August 7th, 2025, at the location of 1043 East Forest Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do on that date involving a Gabriella Bradford that makes you think that you're guilty?
Gabrielle.
Gabrielle?
Gabriella would be my daughter.
Your daughter. Okay.
Me and my wife had an argument and I shoved her.
Okay. What's your wife's name?
Gabrielle Bradford.
Gabrielle Bradford. Okay.
The E at the end.
Got it. I see it. All right. And you shoved her. You did that on purpose, sir?
Yes.
You didn't have her permission to do that?
I didn't. No, Your Honor.
And has you been your spouse? Sir, if I accept your plea, but you commit misconduct as defined by the Michigan court rules between the time that I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea. You understand that, sir?
Your Honor.
And the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be June 1st, 2026, 10 a.m. before Judge Washington.
So
Bond with its conditions will continue.
as soon as possible. I just.
See, I told you.
Prosecutor and we'll get it. Do it. Judge Washington. Okay. Right. Okay. See that. Call me if you have any questions.
Do it. Just no. You just need to have more faith in people.
That Judy did.
Oh, well, maybe not. No, June 1st. Court calls the case, People versus Matthew King.
And then we got the people.
It's just everything in it.
Good morning. Joy Gaines, Senior Assistant Public Defender, representing Mr. King, who's present to my right. Would you please state your name, sir?
It's totally okay. How you doing, Mr.
I'm doing great, Mr. King. How are you? All right. What are we doing?
Your Honor, we did not have discovery yet as of yesterday when I met with Mr. King. Miss Sunda, I'm assuming, because I emailed her at the same time regarding his as the other clients, that we will have it. Regardless, Mr. King wants to schedule the preliminary examination. And he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary exam.
Your Honor, at this point, I would be objecting to that, given that I have come to find out there is more discovery. There's a second venue involved in this case that does have additional video surveillance of the actual assault that occurred in this case. Further, there's going to be more discovery because I was planning to address bond today. So there will be jail calls that could be leading to other charges in relation to this case. So at this time, there are a few things in play here that I do not have yet and that defense does not have yet that I think would be very important for this case, along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, that it could be adjourned if the people aren't entirely ready to go.
That's fine.
Pardon?
He said that's fine, Your Honor.
Been to jail 2 weeks. I ain't did nothing wrong. They always try to do.
Well, Miss King, let me just explain to you though, the problem's gonna be you may be in there longer, sad, and nobody can go because they don't have the stuff and your counsel can't even advise you as to what you need to do. I mean, so that's all I'm saying.
Mr. Simpson, can I say something to him?
Well, I was gonna say, I know
Sorry, I apologize.
that you and I talked about that and you understand that. And you are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in jail.
Well, sir, I don't.
No, he's on a parole hold.
Okay. Here's what I'm gonna do. That the discovery that you have now, you can get over to,
It was sent yesterday, Your Honor.
it was sent yesterday.
Currently, it was sent over yesterday. I'm awaiting further steps along with that surveillance video from where the actual assault occurred. And then potentially, and then Ms. Gaines would also get the jail calls that could be leading to future charges as well.
As to the witnesses currently charged, you would at least have police officers that could testify, correct? Because I'm gonna do something with the date because everybody seems to be in a hurry. So I'm gonna set an in-person preliminary examination. I'm gonna set it for April 28th, 2026, a few days. Hang on. 9 a.m. That's before me.
Thank you.
as your bond.
Your Honor, it's come to my attention that since being arraigned, Mr. King has been making calls to his family, that his sisters, I believe his mother. In these calls, he says, my son don't need to come to court, man. You don't need to come. Talk to his mama. Talk to his mama. You're right there. If you want to help your nephew, you need to get on that phone and talk to his mama. That's what I said. It's gonna kill him in the end. She's supposed to be on it. I know what I would do. And further things telling them they need to talk to the victim's mother. The victim is his minor son, so he's asking them to talk to the victim's mother to try and get him to not come to court and to guilt him into coming to testify against his father. So I suspect this could be leading to future charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few that occurred after arraignment. And Mr. King is also on parole for a witness intimidation interfering case as well.
Okay.
Your Honor, Mr. King did indicate to me that because this involves a family situation, that he had spoken to his mother and his sister. He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time. So the preliminary exam is April 28th. I know that you typically cease phone calls. I just want to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
Well, I'm
cannot have only direct contact, Ms. James, as you know, he can't have indirect contact.
correct. I'm not disagreeing with that. I'm just saying that based on our and terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with his family went.
All right, what I will do is I'm going to read the people's request. The defendant's phone privileges and texting privileges are hereby ordered revoked. Sir, do not do that.
You always take my phone. I haven't did anything wrong, Mr. Sir. I haven't did anything wrong.
Want a hearing on it? Because I'll have to listen.
Let's do a hearing today,
Want me?
because I need to talk to my family. I have things going on.
Sir, Mr.
I want to do one today. Like you taking my phone, Mr. Simpson, and I ain't called them. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted none of them.
Bond conditions were that you cannot have third-party contact or direct third-party.
I haven't.
Okay,
I haven't, sir.
are you gonna listen to me? Because if you're not gonna listen to me, then I'm not gonna listen to you. Okay, you can shake your head all you want. I'm just gonna leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm gonna do it. Yeah, we're gone. We're done. Court calls the case, People versus Danita Combs.
If you're on that?
Yeah.
That's us for the people.
Where we are on behalf of the Danita Combs.
Yeah, it's me.
Hello, what's your name?
Danita Combs.
Okay. What are we doing?
Judge, we do have a
Deck of cards. Go ahead.
judge, you're asking for an adjournment. We're trying to establish contact with Ms. Combs so that we could review the report with her judge.
Probable cause conference will be adjourned then to May 7th. Ms. Combs,
Yes,
you need to contact the public defender's office. You have their number?
I believe it's 222, hold on. I think I just dialed it.
222-6970.
Yeah, I called them today, and I thought I
called
talked
them.
to them yesterday.
Just
I mean,
listen. You need to call them, make sure they have a good phone number and email address for you so that they can contact you and go through what's the matter with you, okay?
Okay,
All right, I'm adjourning your matter out a couple of weeks to the 7th, 9 a.m.
okay,
Okay?
thank you.
Thank you, Jeff.
Bond will continue. Thank you. Court calls case People versus Kenneth Mays.
Focus for the people.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Mays.
Morning. Good morning. What's your name, sir?
Kenneth May.
Thank you. What's he doing?
I don't know.
Tell him to stop. It was better when he was in that little box.
Aw.
I know. But so true. All right. What are we doing on this?
So first of all, Your Honor, this matter was adjourned to today so that Mr. Mays could determine if wanted to have a hearing on the bond violation or if he or did not want to have a hearing. At this time, he is not asking for a hearing. He's asking that the court find his admissions to having used be sufficient, and is also asking for immediate sentencing to, I believe he has 8 days credit with credit for 8 days served, to 8 days with credit for 8 days served, and that his bond be reinstated. Yes, so he can return to work. He does have a good job at a warehouse at Haggerty, of course. I think that's Canton, but I'm not quite sure.
I'm sorry?
I think Haggerty and Ecorse is Canton, but I'm not sure.
Okay. Your response from the people.
Your Honor, I think the last time we were here, the defendant admitted to that he had used things before he was arrested. I don't recall a specific admission to things while he was on bond. So I just wanted to make sure the record was clear as to that. I think he was saying he wasn't sure how the amphetamines were in his system on April the 16th. So once the admission is on the record, I have no opposition to him getting credit for time served, being placed back on bond.
He's admitting to that at this time.
Okay, to the use of the amphetamine after the point he was placed on.
That's correct.
Yes, sir.
Was this testing? I wanted everything done. So what I'm gonna do. So what are we doing with the case itself?
We still gonna set this for preliminary. Is that correct?
Oh, no.
Okay. Your Honor, may we have an adjournment? I will fill out a green sheet so that we can see if we're going to be able to work something out. Our conversation focused mostly on violations.
I got you. So I'll adjourn this out, sir, to May 7th, 2026, 9 What I will do is I will accept the defendant to the violation. I'll sentence him to 8 days in jail, credit 8 days served. I will indicate that his previous bond is reinstated with all conditions, including testing. So you're gonna go back on testing. You understand that?
Yes, sir, I do.
Now we're real clear what happens if it shows up dirty.
Yes, we are.
I'm crystal clear, right? Okay, I got you. Okay.
Right. Right, thank you, Ron.
Wait. Yes. Get, where is? Bellinger
Yes, Your Honor.
and counsel on this one approach. Who's on the other side of you?
That's gonna be, Ms. Feltus.
Oh. Didn't work. Now it did. Don't question me when I here to tell you something. You know what, Alan? Don't say sorry. Court calls case People versus Enrique Davis.
People.
And good morning, Your Honor. Assistant Public Defender Alexis. With and on behalf of Mr. Davis, who should be appearing on Zoom.
Yes, Eric Davis.
Okay, Eric Davis. All right, he's here.
And Your Honor, I do have a green sheet. We're just asking for a brief adjournment to continue some discussions with the prosecution.
May 14th, 2026, 9 a.m. Bond continued.
Your Honor.
Thank you.
Thank you.
Thank you, sir. Court does call the case People versus Michael Moore.
Morning, Your Honor. Raymond Cook with the people.
All 5 cases.
Yes.
Oh, you got to be on that side.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Moore. Would you?
Your name, sir? Spencer Moore. Thank you. What are we doing?
Your Honor, Mr. Cook indicated today that there will be new additional charges authorized as to Mr. Moore. So there are more cases coming. And we have been talking about trying to work out a global resolution. So we'd asked for a short adjournment in order to have those cases track. Yes.
Okay. Mr.
Cook.
Cook.
I see 2 additional requests in the queue. I'm planning on getting those reviewed tomorrow morning, so shortly here. I did also just want to clarify, I believe that there may have been a stipulated order for release to treatment. Does the court have that? I don't know if that was submitted yet or if that was.
And
I don't think I have that.
I believe that a stipulated order was submitted by Miss McGee when we were in court last time. But if Your Honor does not have that, I will look into it again. And I will double check. I did work on one with Mr. Childers for the first case that he had.
So it may be one, but not covering all cases.
The only reason I bring that up is I was checking XGL. I do see he has out of county holds. I'm not sure if that's going to affect his release to treatment.
Got it.
Because I see, I believe it's out. Check here, Dieter Warren. There's a hold for another larceny from a motor vehicle there.
Probably going to be a problem because I'd be releasing him on a PR to treat with a tether.
I will have one of our paralegals see if we can resolve that outstanding warrant. They've had good success with that in the past.
Yeah.
Yes, they have. I'm really impressed with what they've been able to do.
Your interns?
Well, I'm sure the interns could too, but the paralegals.
Oh, I
Couple of them.
don't like any of your paralegals. Just thought I'd say that out loud. All right.
Let me know.
You're welcome. Other charges that are coming. I want to give a date so we can try to get everything together for this gentleman. If I put it out 2 weeks,
I'm going to try and get them reviewed and either have a decision tomorrow. I don't know how long.
Okay.
Officer to come in and swear to the new charges, if any.
Okay. If we can get those done, then get him arraigned on those.
2 weeks should be fine.
Thank you, Ms. Fount. All right. I will adjourn these then to May 7th.
Thank you.
Thank you. Court calls the case, People versus Philip. Petruccio.
Your Honor.
Your name, sir?
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Di Patrizio.
What are we doing?
Your Honor, I do have a green sheet in this matter. We are asking for some additional time for investigation and ongoing discussion with the prosecution. We would also like to address bond.
Well, during the matter to May 14, 2026. All right, as to bond.
Your Honor, Mr. Di Patrizio is on a GPS tether, and we are asking if the court would consider removing the tether. Since he has been on the tether, there have not been any violations. He has not gone to the hotspot. This is his first, it's my understanding, this is his first contact with the criminal justice system. He is asking that have the ability to, in addition to being able to have the tether removed, that he would also.
Who's the alleged victim to him?
I believe it is his former partner, the mother they have a child in common. And he is also asking that they be able to have some contact as with regard to the child in common, no other contact.
Is there a divorce pending? What's going on?
My understanding is that there was a messy divorce with
It was a what?
a bit of a messy divorce, but that I believe
And after that
finalized.
came out?
Pardon?
Yeah.
Yes.
Okay. And so there's messy divorce. These charges come out and you want me to remove the tether.
That is his request, Your Honor.
All right. Response.
This is the second count on this, and the first, you have aggravated assault, or aggravated stalking in the past, which was dismissed, and the contract had continued. They previously had, some contact in regards to, however, he violated that, and so that was removed. Think he would speak about the children, but then also speak about other things. The victim has expressed that she's extreme emotional distress, and that she feels from the type of communications that he with her. So at this time, we the other remain as well as the no contact and no go to.
Anything else?
Just for clarification, Mr. DiPrizio is saying that he has not had any contact with his former partner, that any contact he has had has been with his daughter. And it's my understanding that in the divorce decree, that there is contact permitted for the purposes of visitation, other like that with regard to his daughter. So that is all, those are the only two modifications he is requesting. He has no prior convictions, is that right?
Well, you're requesting a modification to take off the tether.
Yes.
Really what you're asking.
Yes, and he spent 3 days in jail on this matter already, so he is very, very sure that is not a place he wants to return.
Given all the circumstances, motion for bond modifications denied. I'm going to leave everything in place. So his bond will continue. We'll see him on the 14th. Thank you.
Your Honor.
Thank you. Court calls the case People versus Angeles Warren.
Joy Gaines, Senior Assistant Public Defender. We need help.
Okay, fine. I'm so.
Gaines, Senior Assistant Public Defender, representing Ms. Warren. Your Honor, when we were before the court last time, Miss Warren was in the Wayne County Jail and we're not aware of that in time enough for her to.
Have not signed in. I think there was a writ and everything done. They just haven't.
That is correct. I have no explanation for her whereabouts.
I'll adjourn it to May 7, 2026, 9 a.m.
Thank you.
Some cooperation. Thank you. Propose the case People versus Jaquia Dunlap.
Your Honor, for the people.
Put the four short Feaster, defender on behalf of Taquaya Dunlap. I've called that name here in the courtroom, Judge. Don't know if they're on Zoom or not, but they do not appear to be in the courtroom.
I'm here. I'm sorry. I'm just trying to get some lighting for you.
You want to do what?
I was just trying to get some lighting, like turn my light on for you.
Okay, you did a good job. What's your
I'm
name?
sorry. Yeah, thank you.
What's your name, sir?
Jacques Dunlap.
Thank you, Judge.
You're welcome.
Have communicated an offer to offer to the client, I believe. He is still considering that. We can have a brief 1 or 2 week adjournment. We'll be that matter for.
Probable cause conference, May 7, 2026, 9 a.m. Found continued.
All right, thank you.
Thank you.
Thank you.
Thank you, Judge.
Wake you up. Yeah. Done this. What was he doing? Just sitting there? Sleep?
Tend to watching gallery.
He was focusing on, oh, I see. Okay. Nice save for him. I don't know why you take his side. Court calls case, People versus Man Davis.
Morning, Your Honor. Assistant Public Defender Alexis Zerb on behalf of Mr. Davis, who is approaching. Mr. Davis, can you please state your name for the record?
I know. What's your name? Name? Man Davis. Thank you.
Your Honor, we were originally expecting to do a waiver today, but Mr. Davis is on the magistrate's docket this afternoon for a new case. So we figured we should hold off for that case to come with these other cases.
Okay.
Ask for maybe the 1 week, because I would anticipate that his probable cause conference in that matter would be set for next Thursday.
Well, maybe. Okay. Where's the hand? Oh, why are you there? Where's the other one? Where'd she go? He's supposed to be in here when I need him. Hold on a moment, folks. We have some disruption in the office. You don't know. Okay. Do you know if all of the paperwork has gone through regarding the new case?
I would hope so, Your Honor. I know the swear to took place yesterday.
Did. Okay, so hopefully the paperwork. So can we let them know to set this for the 30th? All right, so I'll adjourn these out next week. Then that other one, let that catch up.
Perfect.
Okay?
Yeah.
So I'll adjourn these to April 30th. All right. See you then.
Thank you, Your Honor.
Court calls case, People versus Tawan Edison.
Your Honor, Raymond Show for the people.
Judge. Four short Feaster, Assistant Public Defender on behalf of Edison. I've called that name here in the courtroom in the hallway, Your Honor. I don't know if he's on Zoom or not.
All right.
Negatory.
For the record, Judge, I do not know why they are not present. I will be requesting an adjournment, but I do not know where they are.
Bench warrant will issue for defendant's failure to appear. Bond set in the amount of 10,000 cash. The warrant will issue immediately. The court does call the case People versus Coloni Franklin.
Ms. Talani Franklin. One state your name for the record. Talani Franklin.
Thank you. Really? All right, now. Since you'd be out of these by now. What?
I signed that, right, Judge?
Okay, pressing an adjournment.
That's correct, Your Honor. There were just some videos that we saw online that we wanted to review with Ms. Franklin.
May 14th, 2026, 9 a.m.
Thank you, Judge.
Round will continue. Thank you, ma'am. You're back. Oh, hey. Hi, no, don't worry about it. Nice to have you back. Court calls the case, People versus Zachariah Haruska Dennis.
Jacob Kennedy for the people here on.
Surname anyway. No, okay, whatever.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Hurska Davis. Dennis, I'm sorry.
Her name?
Zachariah Haruska Dennis, Your Honor.
Thank you.
We're requesting an adjournment for some additional, for ongoing discussions and an opportunity to do some mitigation.
He's in circuit court on a bunch of other things, right?
But
He was, but not now.
yeah, led to those cases back in February.
Got it. Okay.
We would also like to request an opportunity for him to go to substance abuse treatment court.
Pardon?
We would also like to request an opportunity for him to go to inpatient substance abuse treatment, if the court would be open to that.
What's the people's position?
Your Honor, I certainly understand the court's general policy on this inpatient treatment as we have over here in this. Court that during the last case, the defendant was listed as left inpatient treatment. That's right. Given those facts, given frankly how close we are to the last plenitude case of when checked.
You learned your lesson, haven't you? Will stay in treatment.
Yes.
Probable cause conference will be adjourned May 7th, 2026, 9 a.m. I will not allow release to treat. In this case, I do recall that.
Okay, thank you.
Court calls case. People versus Dallas Fritz. You'll have to leave, sir.
You're welcome.
And is it on behalf of people, Your Honor?
Assistant Public Defender J. Bellingham, Rich, in appearance via Zoom. It looks like, Rich, can you?
Yeah,
state your name for the
hello, how
record?
you doing? Dallas Fitz, Your Honor.
Thank you. I have before me a plea form that indicates that he's going to be pleading to count 3, the malicious destruction, pleading no contest to the charge of malicious destruction of personal property, 200 to 1,000, a 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay full restitution and continue with his substance abuse treatment. That's the court's full understanding of it.
For the people, Your Honor, yes.
That is also our honor.
Mr. Fritz,
Yes, Your Honor.
can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name for the record.
Dallas Fritz, Your Honor.
All right. You can put your hand down. Sir, court's understanding that you're going to be pleading no contest to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. Fine could be increased at the potential value of the property taken if that's greater than or destroyed. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, well, two things about a no contest plea. I have to make sure that you understand. First thing is, why is my screen doing this? The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Basis for the no contest plea.
Pure potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
Guilty, Your Honor.
Really?
No contest. Mr.
Sorry,
Fritz.
yeah, no contest. Is that I didn't know. I had to specify and say that.
No,
Sorry.
it's okay. We got you straight. All right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed or had someone sign an advice of rights form on your behalf?
Yes, Your Honor.
Any question regarding any of those rights?
No, sir.
You understand you're waiving all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes, sir.
Were you on probation at the time of this offense?
Yes, sir.
All right. You understand that your plea in this case could be a violation of that probation.
Correct. Yes, sir.
And you understand that as such, that other court could sentence you to the maximum allowable under those other under that other charge or charges. You understand that?
Yes, sir.
And understanding that, do you still wish to plead to this charge?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. The court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 25-68296. Any objection to the court having reviewed that report?
No, sir.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be May 28, 2026, 10 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond.
Thank you, sir.
Thank you. Bond will continue with its continued.
Thank you.
You're welcome. Good luck to you.
Thank you, sir.
Court calls the case. People versus Marcus Jones.
Josh Phelps for the people.
Ready, Judge? Court shall please the assistant public defender on behalf of Mr. Jones, who is approaching the podium. When you arrive, Mr. Jones, please state your name for the record. Click.
Your name, sir?
Marcus Jones.
Thank you, Judge. We're trying to move this case forward. If we could set this matter for preliminary examination, please.
Discovery is complete.
To my knowledge, Judge.
And people have their witnesses available the 5th.
We will try for that date, Your Honor. Thank you.
All right. Preliminary examination in person, May 5th, 2026, 9 a.m. before 10 a.m. 10 a.m. before, really? Before Judge Freshour.
May 5 at 10 a.m.
Yes.
Thank you.
Up to the hand. Thank you. Bond will continue.
Thank you, Judge. All right. Oh,
You know what? No. Court calls case, people versus, you need to keep moving. Court calls case, people versus Curry Falk.
on behalf of Falk, who's standing to my right at the podium, please state your name for the record, sir.
Curry Falk.
Thank you. We have began the mitigation process, and I believe there's some lab reports we're still waiting on. We'd be asking for a 3 or 4 week adjournment, Your Honor.
Madam Judge, probable cause conference, May 14, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Court calls case, people versus Ashley Nick.
Your Honor.
Greg Haynes, Senior Assistant Public Defender with me, Ms. Nader. With the
Ashley
record.
Nader.
Your Honor, we're asking for a preliminary exam in this matter.
People have their witnesses available the 5th. Discovery is complete.
That's my understanding, Your Honor.
Court will set a preliminary examination in person, May 5th, 2026, 9 a.m. before Judge Perry. Bond will continue. Thank you.
Thank you. Thank you.
Court calls case, people versus Derek Grady.
Mr. Public Defender Jay Bellinger on behalf of Mr. Grady, who approaches. And can you state your name for the record, Mr. Grady?
Darius Grady. Thank you. He's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination? Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor, and there is an offer on this case.
Go ahead.
The offers to plead as charged with prosecutor's HIDA, sentencing agreement to 5 years probation and no contact of non-individual defendants' siblings.
Yeah, that a correct statement.
That is a correct statement, Your Honor.
People do waive the
Yes, sure. Thank you.
preliminary examination having been waived, defendants bound over to circuit court on a single count.
Acknowledge receipt of information, wait formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
June 23rd at 1:30 with Judge Conkey.
June 23rd, 2026, 1:30, Judge Cook.
Thank you very much.
You bond will continue.
And we'll be in touch with you before that date. I'll be in a different court, okay?
All right, I think I have it. Yep. Court does call the case, people versus Sheriff Allen.
Morning, Your Honor. Assistant Public Defender Alexis Zerbs with on behalf of Ms. Nally. Approaching, can you please state your name for the record?
Shereen Alley.
Thank you.
Your Honor, we do respectfully request this be set for preliminary examination.
Discovery is complete.
To my knowledge.
People have their witnesses available the 5th.
We will track that, Your Honor.
Preliminary examination in person, May 5th, 2026, 10 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case, people versus David Grayson. Hello.
Hello? Apologies, Your Honor. I did not hear the name I thought I heard. Assistant Public Defender Davi Liba for Mr. Grayson.
Mr. Grayson, can you state your name?
David Grayson?
Sir.
And Your Honor, there is a new case. I've been advised that we're going to be waiting to catch up.
That you're waiting to catch up?
So I'm requesting to adjourn to wait to catch up.
Okay. Anybody have any other information on that for me?
I will pull it up here momentarily, Your Honor.
I've been advised that it's some sort of property crime, but I don't know any further details.
That's a big category.
authorized it last Friday. So I will follow up with the sheriff's department to there be a bond violation.
Pardon?
It is not going to be a bond violation, but it
Got
is. beginning.
All right. So let's see if we can get those together. If they happen to get that, what I'll do is I'll set this for May 7th. So, right, 2026. 9 a.m. All right. And so therefore his bond will continue. Thank you, sir.
Thank you.
Court does call the case of the people versus Patrick Rowe.
People,
Morning, Your Honor. Assistant Public Defender Alexis Zerbs with an on behalf of Mr. Rowe, who is approaching. Can you please state your name for the record?
Patrick James Rowe.
Your Honor, we'd be requesting an adjournment for further discussions with the people.
Just the only thing holding it.
Yes, Your Honor.
Probable cause conference will be adjourned May 7th. 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the case people versus Eric Jackson.
Passion falls for the people.
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Jackson.
Your name, sir?
Eric Jackson.
Thank you.
Your Honor, we are asking for an adjournment from Mr. Jackson for ongoing negotiations.
Adjourn the matter May 14th, 2026, 9 a.m. Bond continues.
Mr. Jackson, May 14th. Thank you.
Court calls case people versus Justin Taft. Your name,
Assistant Public Defender Duffy, leave before Mr. Taft.
name, sir?
Justin Taft.
Thank you.
Your Honor, we're going to be requesting an adjournment of this matter. He has some other matters out of Genesee County. His attorney there is trying to get him into that Veterans Court program. And once we have an answer there, I'm going to be attempting to see if we can resolve the matters together.
Okay, I get you. But how long is that? Do they indicate the process? Because he hasn't been screened.
They indicate to me it'll be about a 30-day process.
This is the only thing holding him here?
It is, Your Honor, and I was going to request a release to treatment.
Are the people going to have any objection to a release to treatment?
Your Honor, this time I would. He originally failed to appear in 2022 and was gone on bench warrant for several years. And now is back before Your Honor with 2 new cases in Genesee County. I have concerns about him coming back.
What are the other cases in Genesee?
That I don't know. I can certainly find out. Now he has indicated to me that the VA has told him, and they've indicated this to our office as well, they would have a bed for him at a residential treatment facility in Detroit.
All right. Well, what I'll do is I won't authorize it now, but I'm gonna put this out. If between that time, the parties could talk, because obviously he needs treatment. And I understand he'll get that in the Veterans Court if he's accepted, but if we can start that process earlier, I think that might be a better thing.
I agree.
All right. So I won't order it at this point, but advise the parties to talk. And if the defense believes that there can be certain safeguards placed on and he's at the VA, you can file a motion for the court if necessary.
Thank you, Your Honor.
All right. Sir, what branch?
Army, sir.
Army. I won't hold that against you. All right. Shay wants 30 days out. Is that? I'm doing. May 21st. (2026) 9 a.m. This bond will continue with this. Next, sir. Court calls case People versus Quinte Jenkins.
People. This is a public defender, on behalf of Mr. Joseph Jenkins, who is approaching.
That you were done.
Not yet, Judge. I'll be here till 2:00.
Joy.
This is your name. Judge, you're asking for an adjournment. We just have to review some video footage with our.
Turn it to May 14th, 2026. Bond continued.
Thank you.
Sir.
Okay.
Court calls case People versus Harold Watkins.
Assistant Public Defender Davi Lee.
Forgot your name.
I'm just. Watkins.
Oh, okay. Up there. I didn't know if it.
I thought he was behind me.
Okay.
Assistant Public Defender Davi Lee with Mr. Watkins. Mr. Watkins, can you tell the court your name, please?
Harold Watkins. All right.
Here's the forms.
What are we doing?
We do have a plea agreement. I reviewed these forms, the vice rights and plea agreement with Mr. Watkins, and signing them right here.
Let my staff know.
Unfortunately, I did not, Your Honor.
And Your Honor, that's partially my fault. I was to
No cover for legal.
one that I wanted to get this.
That is.
I apologize. Your Honor.
Still legal's fault.
Absolutely, Your Honor.
I can tell the court what the plea is.
Sure. Well, that's a form coming in.
Very good, Your Honor.
Did you state your name, sir?
Harold Watkins.
I have before me the plea form that indicates that the defendant is going to be pleading to the stated count 2 of operating with the presence of a controlled substance, the 93-day offense, and also an added count 4 of use of cocaine, the 1-year offense. Upon a successful plea to those 2 charges. Well, no, something's wrong. The form indicates that count 1 and 4 would be dismissed, but that's not right. It's
It should
1
be
and
1 and 3.
3.
My apologies, Your Honor.
Counts 1 and 3 would be dismissed. That's the court's full understanding of the agreement.
That is our understanding as well.
Likewise, Your Honor.
May I have him sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Harold Watkins.
Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges. Is that your understanding?
Correct.
First charge is the stated count 2 of operating with the presence of a controlled substance. That's a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court could order you to pay the cost of the prosecution as well as the cost of any emergency governmental service. So you understand that?
Yes.
All right. And also that you be pleading to an added count 4 of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand? Yes. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes.
Still wish to plead guilty?
Yes.
To the charge of operating with the presence of a controlled substance, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
And you signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5, you see a copy on the podium, those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses? May 18, 2020, at the location of Adams near Catherine, city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested cocaine?
Yes.
All right. Were you stopped by the police?
No.
Was there an accident?
No.
What happened?
I pulled the car over and parked and went to sleep in the car.
Okay, you pulled the car over when you were asleep in the car?
Right.
Was the car running?
Yes.
All right. Police arrived at some point? Woke you up?
Yes.
Took you to the hospital?
Yes.
Was there a blood draw?
Yes.
And did that blood draw result in showing in your blood, your blood, either cocaine or its derivative?
Yes.
Do you have any reason to dispute those blood test results?
No.
All right. And at the time you used the cocaine, you knew what you were using was cocaine.
Yes.
Sir, I do have to apprise you that if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
Have I complied with?
Yes, Your Honor.
Court will accept the defendant's counts 2 and 4, counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
May 6th at 10 a.m.
May 6, 2026, 10 a.m. before Judge Barr.
Thank you, Your Honor. And if I could respond.
Pardon?
May I respond? Thank you, Your Honor. Mr. Watkins tells me that he could stay at an address in Ypsilanti with his sister. We have no objection to GPS tethered to assure his appearance. He tells me that he regrets his previous failure to appear and that he had returned to Michigan with the intention of resolving these matters when he was picked up at a traffic stop, and that he will stay in Michigan until they're resolved.
I'm going to deny any request for a change of bond given the failure to appear, but also I'll leave that to Judge Barr's wisdom after there's an assessment on the case.
Thank you, Your Honor.
This time it's denied. All right, thank you. Court calls case People versus Levon Jones.
Assistant Public Defender Davila before Mr. Jones.
Good morning, Your Honor. Levon Jones.
Thank you, sir.
And Your Honor will be requesting a preliminary examination, please. Discovery is complete.
And would the people have their witnesses available the 5th? Preliminary examination will be set May 5th, 2026 at
And Judge Perry.
9 a.m. with Judge Perry.
Thank you.
All right.
Thank you.
Thank you, Bond. Continue. That's in person, sir.
Okay, thank you.
Thank you. Court calls the case People versus Jason Westlake.
And then on behalf of the people, Your Honor.
Troy Gaines, public defender, on behalf of Mr. Westlake. Would you state your name when you get to the podium, sir? You can say your name.
Oh, Jason Wesley.
Thank you.
Your Honor, we're requesting a preliminary exam.
All right, discovery is complete.
That's my understanding.
If I can respond.
All right. People would have their witnesses available on the 5th. Preliminary examination in this matter will be set for May 5th, 2026. It's at 10
Yes.
a.m. before Judge Freshour. All right, Mr. Bond.
Your Honor, it's come to my attention that post arraignment, the defendant made 10 complete calls to the victim's listed number in this report and the number that our office has been using to contact her and have made her through. He also had 142 incomplete attempts to contact that number. In these calls, he tells her things that if she doesn't come to court, it'll get dismissed. I also want the court to note that he has, it's on parole for a DV third and interfering with electronic communications with the same victim, which I believe also has no contact provisions within it. So prior to her, he was also violating that bond, saying things want me to go back to prison. When she starts talking about the case, he said, "You're really gonna say that on here?" and things of that nature. I was high, talking about my case, telling her that I talked to a lawyer, they said she has to come to court, it'll get dismissed talking to the victim. So at this point, I'm gonna ask for phone and text privileges to be revoked, given that he's now violated these bond conditions and his parole conditions for that DV case involving the same victim.
Any response? Ms. Gaines, you may want to push the button on.
Oh, thank you, Your Honor.
I was talking to him before. Yeah. I think it's.
And I also know from the court, these are from his sin.
Who sneezed? It was a dainty little. Bless you.
Yeah.
All right. Thank you, Your Honor. I had a brief opportunity to explain to Mr. Westlake that his privileges, communication privileges will probably be revoked. So he is aware of that, and we are ready to move forward.
All right. Given what's been placed on the record, I will revoke the defendant's phone and text privileges.
Okay.
Bond otherwise will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Lamine Kaba.
That's felt as the people.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps with non-peacock Mr. Kaba, who I did expect to be here in person, Your Honor. Is he
Really?
on Zoom?
Negatory, Ghost Rider.
Your Honor, I would ask for this matter to be passed because we did have a plea agreement reached today going into the health treatment.
Wow. Well, go ahead. What? He's not going to come in the door.
Your Honor, I did speak with him just yesterday and he did indicate he was coming in person, and I have concerns he may have gotten confused between this court and the Fifth District Court because I know previously he had been observing the mental health treatment court at 15th.
Just talk. I'm going to give it in. Go ahead. I'm listening.
Your Honor, we would just ask that I briefly.
Okay, fine. I'll pass it. It'll call it up in the next block.
Your Honor.
I don't know why I gave in to her. Court calls the case, People versus Preston Kelly.
Morning, Your Honor. Assistant Public Defender Davi Lipa for Mr. Kelly. Mr. Kelly, can you tell the judge your name, please?
Preston Kelly.
Thank you.
And Your Honor,
Studying practice.
and Your Honor, we'd like to set this matter for preliminary examination, please. Discovery
is complete.
Yes.
People have their witnesses available the 5th.
Your best, Your Honor.
Preliminary examination will be set May 5th, 2026, 9 a.m.
Yes, sir.
before Judge Perry.
Thank you, Your Honor.
Bond will
now you can go.
Bond, bye. Court calls the case, People versus Kaylee Loveday.
People.
Morning, Your Honor. Public Defender. Your Honor, pardon me, Ms. Loveday. Name has been called in the courtroom in the hallway with no response. We would be asking for an adjournment in order to establish contact with our client. If you would enter a green sheet.
I don't need that. I'm good. Bench warrant will issue for defendant's failure. Bond is set in the amount of 10,000.
Thank you.
Nice try, though. Court calls the case, People versus Caleb Mark.
Your Honor, Raymond Cook for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Martin, who approaches, Your Honor. Martin, can you please state your name for the record?
Caleb Van Martin.
And Your Honor, I am just seeking a brief adjournment on this. I am still waiting on some body worn cam in this matter. We also opened an investigation in our office on this matter, so it might take a little bit of time to get some of the information I'm looking for.
May 14th work for you?
I think that'll be fine.
All right. Probable cause conference will be adjourned May 14th, 2026. Well, what are you doing? Never mind. May 14th, 2026, 9 a.m. Bond continued.
Thank you very much. Good to see you today, Your Honor.
Huh?
Good to see you. That's it for me today.
Okay. Here, sir.
Thank you.
Oh. Court does call the case. People versus Eric Mayfield.
And good afternoon, Your Honor. Assistant Public Defender Alexis Erbs with it on behalf of Mr. Mayfield, who should be present on.
Mayfield.
Your Honor, we were just going to ask for an adjournment anyway to continue plea discussions with the prosecutor.
Mayfield.
Not unmuting, Your Honor. I'm guessing.
What?
Not unmuting. He's there, but not.
I don't know what he's doing. Mayfield.
Perhaps we pass this one to Your Honor and I can get a hold of Mr. Mayfield. Since I already have another one.
Pushing it, lady. All right, I'll put that over with her other one, but her clients will show up.
Thank you, Your Honor.
You're welcome. That block. That's it. All right. You ready, me? Oh, you ready? No, I just want to make sure. Surprise. Court stands in recess. All right. And did you get
So Your
Chicago? Can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right. State your name again for the record.
Lamine Kaba.
Okay, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that, sir?
Yes,
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood. She's gonna be 15 just, is that,
Yes, Your Honor, and I also have the MOU for your Honor's
Thank
signature as well.
all right, sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to the charge of attempted resisting and obstructing a police officer as contained in count 4. How do you plead?
Guilty.
To that same charge as contained in count 5. How do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
No.
No.
Could
Did,
you repeat
did
that?
somebody go through with you an advice of rights form?
Yes.
All right. And did you give them permission to sign your name to it after they went through it?
Yes.
All right. Do you have any questions regarding those rights?
No.
All right. You understand that you're waiving or giving up all of those rights?
Yes.
All right. Are you on probation?
No.
Are you on parole?
No.
You understand also that you're giving up your right to appeal of right?
Yes.
All right. Has anybody promised you anything other than what's been said here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. And also because you believe that you are indeed guilty?
Yes.
January 25th, 2025, at the location of 428 Alston Court in Ypsilanti Township, Washtenaw County, state of Michigan. Did you come into contact with 2 sheriff deputies?
Yes.
All right. Oh, man. I think they were. All right. When you came into contact with the sheriff deputies, what happened?
I came into contact with them and then I tried to go use the bathroom. Well, I acted like I was gonna use the bathroom. Then they try to come in to the bathroom with me to try to do their job, and then I resisted. I got tased, and I mistakenly held the towel rack, and it came out. So it came out the wall, and that's what happened. I got
Okay.
arrested, and
Did
but
you?
yeah.
All right. Mr. Cabot, were at the time that you were trying to leave, did they told you to stay where you were, and were they trying to arrest you at that point?
No,
No?
no.
Okay, what'd you do that caused them to tase you?
I think I was resisting.
Okay, when you say you were resisting, what were you doing?
I tried to close the door on the police officer's foot because he tried to put his foot in the door. Then I tried to
Okay, so
shut
he
the
tried to
door.
put they wanted to talk to you or something along those lines, right? And you put your foot in the door so you couldn't close, so they couldn't close. Well, they put their foot in the door so that you could not close the door, correct?
Right,
Okay. And then you resist, they then tried to arrest you at some point, correct?
right.
And then you did things that resisted that arrest. Is that correct?
Yes,
And that led them to have to tase you. Is that right?
yes,
Okay. And there were 2 officers there at that time?
Yes.
All right. Sir, let me just tell you that between the time I accept your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence evaluation or recommendation would, the court would no longer be bound by. You understand that?
Yes.
Counsels, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied and would like to just make a record that at the original time of contact, the police officers were attempting to contact Mr. Kava because he had left psychiatric emergency services earlier in the day.
Gotcha.
And they were trying to cooperate with the petition to bring him back to services. So he was not going to be subject to arrest necessarily, just to the execution of that petition. It's what the record to be clear about that. So we are satisfied that we comply with the court rule.
Defense is satisfied, Your honor.
Court will accept the defendant's plea to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered to the extent it is at 15th District Court at Mental Health Court. And you had given us a sentencing day. Sentencing
April 29th at 1:30.
April 29th, 2026, 1:30. That's as to us by the public defender.
That's with Judge Garwood.
And that is with Judge Garwood. Bond will continue.
Your honor, may I approach for your signature?
So we have to keep this right. Bond will continue. Court calls the case People versus Eric Mayfield.
And good afternoon, Your Honor. Assistant Public Defender Alexis Serbs with and on behalf of Mr. Mayfield. Mr. Mayfield, can you please state your name for the record?
Eric Mayfield.
All right, what are we doing?
Your Honor, we would just request an adjournment for continued discussions with the people.
Probable cause conference, May 14th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you. Court calls the case People versus DeMarco Henderson.
Good afternoon, Your Honor. Reeves.
Here you are.
Mr. Henderson, can you state your name, please?
DeMarco Henderson.
What are we doing?
Setting for a preliminary exam.
Discovery is complete.
Come on, Alex.
Pardon?
Come on out.
And would people have their witnesses available on the 5th?
Do our best, Your Honor.
Preliminary examination in person will be set May 5th,
Your Honor.
2000.
Sorry, Your Honor, I'm in a already paid for scale conference that day. 2 days, actually. Can I have
Want
another,
a different day?
please?
Will the 12th work for you or
It will. Thank you.
objection from the people?
Done, Your Honor.
May 12th, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you. Court calls the case People versus Coisha Pitt.
Good afternoon, Your Honor. Reeves.
Good afternoon, Your Honor. Christina Saxon for Ms. Pippins, who's
Am I
approaching.
allowed to leave?
Yes, Mr. Kava, you can leave. Your name?
Coisha Pippins.
All right, what do we,
We're setting for preliminary exam.
discovery is complete?
Yes, it is.
And do people have their witnesses available the 12th?
Yes, Your Honor.
Preliminary examination in person, May 12th, 2026. 9 a.m. before Judge Washington.
Thank you.
Thank you. Bond will continue. Court calls case People versus Demetrius Caldwell.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Caldwell. Mr. Caldwell should be on Zoom. And then Mr. Caldwell, if you could state your name for the record.
Demetrius Caldwell.
Thank you. Your Honor, we did receive a report regarding Mr. Caldwell's competency. I did provide a copy to the court. So at this time, I think we're just asking that that be entered and set a review date for approximately 90 days.
No additional evidence from either side.
That's correct. There is no additional evidence from people. We ask the court accept the report from the Center for Forensic Psychiatry. We stipulate to its omission of no additional evidence.
To indicate that this report, it does indicate, and the court has reviewed it, that the defendant at this time is incompetent to stand trial, but likely to obtain confidence. And counsel, I would need an order
Okay.
for the court, please. I will set a review date. Because we can always move it up.
July 23rd.
Set a review date for July 23rd, 2026, 9 a.m.
Thank you so much, Your Honor.
You, bond will continue. Court calls case of the People versus Rachel Pichette.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Pichette. Ms. Pichette, if you could unmute your mic and state your name for the record, please.
Rachel Pichette.
And Ms. Pichette, well, I have before me a plea form. Is that what we're doing?
Yes, Judge, that is what we're doing today.
Form indicates that the defendant will be pleading guilty. Well, it doesn't say.
Yes, pleading guilty, Judge.
Yes.
Pleading guilty to the charge. Use of heroin, the 1-year offense.
That's correct, Judge.
Upon their successful plea to that misdemeanor charge, count 1 would be dismissed. It is also the agreement, the defendant agrees to be placed on probation with drug treatment as a term of that probation and as deemed appropriate by probation or any designee. That's the court's full understanding of the agreement.
That is correct, Your Honor.
And that's correct, Judge. And we've had an opportunity to discuss her trial rights. If you'd like to waive them, accept the offer that the people have tendered.
Pichette, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, state your name again for the record.
Rachel Pichette.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of heroin. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes, I do.
All right. In understanding that, you still wish to plead guilty? Well, I
Yes,
do
I
have to
do.
advise you one other thing. Although I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Correct. Yes.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, not at this time. Thank you.
All right, you signed, actually, I'm gonna need her to sign a misdemeanor advice of rights, signed a felony advice of rights.
Okay, Judge, we'll get that submitted to the court.
You understand that they're contained on the form, but not under paragraph 5. You understand that those rights that are on there, that you're waiving those rights?
Yes, I understand.
All right. Are you on probation or parole?
I am currently on probation in your courtroom with Miss Pilara.
Yes. And were you on probation at the time of this offense?
I'm not sure.
Your Honor, this is from 2022.
It's from 2020.
So
Well,
no, I don't think so.
looks like they changed that to 2020. All right. Then she still would be on probation to be at this time in either case, quite frankly. All right. You understand that you're giving up your right to appeal of right?
Yes.
You're not on probation you're not on parole at the time of this offense. Has anybody promised you anything other than what's been stated here today to get you to plead?
No,
Anybody threaten you or coerce you?
no.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. And also because you believe that you're guilty?
Correct.
On, looks like September 22nd, 2020, I think is the complaint has been amended.
Yes, Judge. I apologize.
Did you have heroin in your possession?
Yes, I did.
Had you used it?
Yes,
Did you know what you were using was heroin?
yes.
All right, ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea. And the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand, yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
Clerk satisfied.
Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
May 28th at 10 a.m.
May 28, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you so much, Your Honor.
Thank you.
Here. Court calls the case of the people versus Naya Lee.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Lee. I am standing in for her attorney of record, Attorney Costantino. Ms. Lee, can you unmute your mic and state your name for the record, please?
Naya Lee.
And Ms. Lee, are you okay with me standing in for Ms. Constantino, giving you the adjourned court date?
Yes.
Your Honor, there is another matter that we are tracking, and there are ongoing negotiations. That other matter has a court date of May 5th, so we are just asking for a date after that date.
May 14, 2026, 9 a.m. Bond continued. All right. Thank you. Thank you, Ms. Lee. Court calls the case people versus David Shukai.
People.
And good afternoon, Your Honor. Sydney Rushing on behalf of Mr. Shukite. Mr. Shukite, can you please unmute your mic and state your name for the record, please?
Yes, ma'am.
Can you state your name for the record, please?
David Patrick Shukite.
Thank you. And Mr. Shukite, I am standing in for your attorney of record, Christina Constantino, as she is stuck in another courtroom. Are you okay with that?
Yes, ma'am.
Your Honor, at this time, discovery is complete, and we'd like to ask for a preliminary examination date to be set. Any date works.
People have their witnesses available the 5th.
Do our best, Your Honor.
Preliminary examination in person, May 5th, 2026 at
10 a.m.
10 a.m. before Judge Freshour. Bond will continue.
Thank you so much, Your Honor. Great to see you as always.
Yes.
I told you I'd be in person. I came in person. I just want you to know.
Happy. All right, you're okay. You're all set, Mr. Shugate.
Thank you, sir.
Thank you. Court calls case people versus Emmanuel under All right, I was close. I think. All right, counsel, state your appearance, please.
Joy Mohammed on behalf of Mr. Uduchukwu. Emmanuel, please state your name for the record.
Emmanuel Uduchukwu.
Thank you.
Your
All
Honor,
right, what are we doing?
I asked for this additional PCC after a couple of weeks ago in order for an opportunity to fully address bond. We had a lot of different issues that we presented at our first PCC. We have a motion that is still outstanding, but my client currently has a GPS tether. We're asking for the court to consider removal of that GPS tether because it doesn't serve the purpose which bond is intended, which is to make sure that the community is safe and make sure that my client comes to court. He has no KPS history. This is a 3-year-old case. And during those 3 years, he had no interactions with the police whatsoever. And so There was an issue last time we discussed as far as what would be the exclusion zone. I don't know if the people have identified that exclusion zone yet, and if they have, I would like for that to be entered into a court order. But like I said, the current tether placement doesn't serve the purpose of, what we as a community put people in tether for, and it's causing a financial burden on my client. He, it's causing attention for him at work, putting his job in jeopardy, which he needs to pay for the tether. So we're asking for it to be removed.
Your Honor, I'll answer that in two parts, really. This is a criminal sexual conduct first-degree case involving a minor. The court would be well within its right to deny bond on this case based on that offense alone. I would simply ask to have it remain in place until the date of that motion hearing, so that this court would be fully apprised of what is going on in this matter. I did receive information from my victim's advocate about the exclusion zone that counsel was mentioning just yesterday. I did talk with court staff about the best way to get that over to you, but I'm going to do that this afternoon. I would ask them to remain in place. 5-7.
I took the home confinement off.
That's correct, Your Honor.
All right. And is there then gonna be another motion before me?
There is
It's
an
a
additional
longer
motion. Counsel Miller hearing that is.
Right. Okay. All right. Well, other than what I had ordered previously, I don't hear anything that's going to necessarily change my mind. And counsel's right. I could deny bond, which I think would be absolutely inappropriate in the case, at least based upon what I know. But I don't think that the tether is necessarily inappropriate given the circumstances of the case. So I'm going to deny the request for any further change in modification of the tether at this time.
May I ask if the people have the can he clarify as far as what the exclusion zone, what's going on with that?
I have the addresses. I'm going to provide them to staff today.
I'm sorry, I didn't hear you.
He has the addresses. He's going to provide them to staff. Are you talking community corrections staff or?
Yes.
Going to provide them to community corrections, and the defendant is notified, but we will not state those addresses in open court.
Thank you. That's fine. That's fine. All right.
Oh.
Thank you, Your Honor.
Thank you. So what I will do then is I will set this probable cause. Your motion is already here. It's set. So I'll keep the probable cause on that same date at May 5th, 2026, 2 p.m.
Okay. All right. Thank
fine.
you. And that will be in person.
That'd be in person.
Thank you.
Thank you.
That the 5th or the 7th, Your Honor? 5th is a Tuesday.
It's giving me special date.
Oh, for the motion hearing.
For the motion here.
Thank you.
Correct. Court calls case People versus Jacob Halfacre.
Your Honor, Michael Vincent on behalf of Mr. Halfacre, put your name on the record.
Jacob Halfacre. Thank you.
Your Honor, I understand that on Monday of this week, the defendant entered a plea in a different case in the 15th District Court. And that part of that plea is dismissal of this matter. So this time I'll be moving to dismiss. I'll get you a nollie probably by end of.
On both counts.
For the whole case.
Yes,
Should include both counts.
thank you.
You're trying to trick me, weren't you? Jesus. Best.
Thank you.
Thank you.
Well,
Good luck, Mr. Halfacre. Court calls the case People versus Josiah Miller.
Question about this for people.
David I. Goldstein appearing on behalf of the defendant. Mr. Miller, state your name, please.
Josiah Miller.
Thank you. Speaking in adjournment.
Yes, Your Honor, there's some additional discovery that Ms. Feltus and I discussed.
That's correct.
14th work for you?
That's fine for my
I
health.
was looking at the 7th, Your Honor. Is that not possible?
Oh, I can do the 7th.
Yeah, 7th.
That's attorney asking for less time. All right, go ahead. May 7th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Court calls the case People versus Denise South.
Good afternoon, Your Honor. Attorney Ryan Reeves here, 73195, on behalf of myself, would you identify yourself for the record?
Denise Self, good afternoon, Honor.
And then, Your Honor, you can approach, please.
Yes, I guess. He traveled to Ohio, almost Kentucky. Said May 1st to the 3rd.
Correct.
That includes your travel days?
You repeat that, Your Honor?
That includes your travel days?
Yeah.
I mean, you're gonna be traveling on the 1st and the 3rd.
You're leaving on the first, coming back on the
Yeah,
third.
yes, Your Honor.
May 1st through May 3rd. All right, so I give him permission to do that. I've set your preliminary exam date. Bond will continue.
Thank you, Your Honor. Have a great day.
All right, you too. Court calls case People versus Seth Zaharanik.
For the people.
Good afternoon, Your Honor. Marissa Voiles, P 86438, appearing on behalf of Mr. Zaranik. Will you state your name for the record, please?
Seth Zaranik.
All right. I almost got it right. Okay, what are we doing?
Your Honor, we're just requesting an additional PCC be set for ongoing negotiations. We would waive the 21-day rule.
All right. Will the 14th work for you? Or the
That's fine.
7th? Which-
The 14th is good.
All right. During probable cause conference, May 14th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Great. Thank you. Court calls case People versus Alyssa Anala.
People.
Good afternoon, Your Honor. May it please the Honorable Court, David Birch, on behalf of Alyssa Anala? Okay,
Anala.
Anala, yeah. Different emphasis on the different syllable, Your Honor. So,
Yes, all right.
Melissa Anala.
All right.
Your Honor, I've spoken with Ms. Feltus in this matter. There may be a district court resolution. We're asking for an adjournment of the probable cause conference.
All right. 7th or the 14th?
14th, Your Honor.
Probable cause conference, May 14th, 2026, 9 a.m. on continue. Thank you. Court does call the case People versus Matthew Kennedy.
Good afternoon again, Your Honor. May it please the Honorable Court, David Burgess on behalf of Matthew Kennedy, who's appearing via Zoom from Bear River inpatient.
Okay, he's in there. All right. Sir, state your name.
Matthew Kennedy.
All right. What are we doing?
Your Honor, because he's obviously trying to complete an inpatient treatment, which I'm not sure how far into it is, but I'm asking the court to consider or an adjournment of the probable cause conference.
Sir, how much more time before you know what your outdate is, or do you know what your outdate is?
Tomorrow.
Oh, your outdate's tomorrow?
Yes, sir. And I'm on tether still.
Pardon?
I'm on a tether.
He's on tether still, he said.
Yeah, you're on tether. Okay.
Yeah.
And then from there, are you going into a sober living type of circumstance?
Yes, sir.
All right. So here's what I'm going to do. I'm going to adjourn this out to the 14th.
Thank you.
2026 at 9. That way, that'll allow you to get settled where you are.
To what date?
Okay. The 14th of May.
Thank you.
All right. Your bond will continue. How did it go for you up there?
It's doing good. I've opened up on a lot of things that I've kept aside, and I see a lot of problem areas I had in my life, and I'm working on those.
So it worked out. It's working out for you.
Yes, sir.
Right? How does it feel to be? How's it feel to? Is this the longest time you've been sober?
Probably not that much, but yeah, this is the first time I feel good about myself.
That's fantastic to hear.
Thank
All right. All right. Well, you keep it up. Okay.
Yes,
And
sir.
we'll see you on the 14th.
Say May 14th.
Yes, May 14th.
All right, do Zoom or in person?
Well, you can talk to your counsel. You may be able to appear via Zoom.
All right, I'll call him. I'll call him tomorrow, or I'll call him later
Okay.
today.
All right. We'll figure it out.
Okay.
Thank you.
All right. Take care.
So,
It's gonna have to do that. Cause I'm done. Court calls the case, People versus James Young.
For the people you're on.
Good afternoon, Barton Morris, appearing on behalf and with Mr. James Young. Can you state your name for the record?
James Young.
All right. And what are we doing?
Your Honor, I'd like to ask the matter be scheduled for an examination.
Discovery is complete, sir.
Yes.
People had their witnesses available the fifth.
Your Honor, I have a trial scheduled on that date.
Ozzy's trial. Oh, no. All right. Well,
Cancellation. Better day, another day would work better for me as well. Your Honor.
oh, okay. Well, I don't really care about that. No. Will the 12th work better? Count for I can go 12th or 19th, whatever you'd like.
Okay. Take it a second.
Both of those bad?
And
What?
just spinning, yeah, I'm waiting for. Oh,
No, I think
in the morning, I presume?
they're in the morning.
The 12th, Your Honor.
12th. Preliminary examination in person, May 12th, 2026, 9 a.m. That's before Judge Washington.
Thank you.
You're welcome. Bond will continue. Thank you. Okay, looks like you're on this one.
His client didn't have a camera.
Oh, that's right. Court recalls case, People versus Cherry Williams.
Good afternoon again, Your Honor.
Good morning. Good afternoon, Your Honor. On behalf of Mr. Williams, Attorney Nicholas North, Mr. Williams, can you please unmute and state your full name?
Here's Terry Williams.
All right, thank you. All right, what are we doing on this?
Judge, I would like for the matter to be set for a preliminary exam, please.
Your Honor, I don't believe discovery is complete. Defense counsel reached out to me last week. Unfortunately, I was on vacation for most of last week, so I didn't see that email until earlier this week. I submitted a discovery request with the officer. I've not gotten a response from that yet. So that additional discovery is not yet available.
This is additional discovery over and above.
It's some footage that I believe the officer indicated in the report that they viewed, but we don't have.
What do you want to do, Mr. Noor?
We can wait for the video. That's fine.
How, so you say you've gotten it?
I reached out earlier this week. I have not received a response from the officer yet. I can follow up this afternoon to see what the status of that is, but I don't have it yet.
All right. Will the 7th or the 14th work for you? Which day would you prefer, Mr. North?
The 7th is fine.
All right. Probable cause conference, May 7th, 2026, 9 a.m. Bond continued. Thank you.
Can I say something?
Mr. Williams, no, just log off, please, and call me. Okay, call me so we can talk about it.
Okay.
Thank you.
Thank you. Thank you for that, Bob. Sweet. Court stands in recess. Court does call the case, People versus Jessica Wilson.
Ashley Belts, the people.
Your Honor, she is present by Zoom. Joy Gaines, Assistant Public Defender. Ms. Wilson, would you please state your name?
Ms. Wilson? Oh, she was behind my corner.
Oh my God.
That's not Ms. Wilson.
Hello,
There she is.
Jessica Wilson. I'm sorry. Is my phone is super low. Can't hear nothing.
Let's hear it. Yes, Your Honor.
Okay. Ms. Wil, you okay, Ms. Wilson?
Yes, it's just I can't hear. My phone is low.
Okay.
All right. Ms. Wilson, you're asking for it.
Yes. Yes, we have ongoing negotiations.
Ms. Wilson, I'm going to adjourn your case to May 14th.
Okay.
Okay, she heard that. All
Thank
right.
you.
You're welcome.
Thank
All
you.
right.
It's at 9. All right,
Okay.
take
Bye-bye.
care. Bond
Thank you.
continued. Court calls the case of People versus Desmond McCaster.
Good afternoon, Your Honor. Reading the people.
Good afternoon, Your Honor. Assistant Public Defender Alexis Serp, standing in Bellinger on behalf of Mr. McCaster, who's approaching. Your Honor, I believe there had been a green sheet submitted on this matter. We had not been able to make contact with Mr. McCaster prior to today, but we have plans to get in touch with him, so we just request a few weeks.
May 14th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Taisha Morgan.
Good afternoon, Your Honor. Raymond Cook.
Judge, Portia, please to Assistant Public Defender on behalf of Ms. Taisha Morgan, who I believe is
Right there.
yes, state your name, please.
Name.
Taisha Morgan.
Thank you.
Thank you, Judge. I believe you should have a green sheet in the file.
Hey.
Thank you. I'm requesting a brief adjournment to try to get a result.
Where's Cannon?
No, I don't think she's here today. I think she's off today.
Off every day, but I mean,
Well, she's not working.
oh, not work. May
At
14th, 2026, 9 a.m. Bond condition.
Thank you, Judge.
Acting really, you know where she is. Where is she?
I don't know her. I can call her, telling you.
You what?
I'll call her, Judge.
Call her now. I want to know before I finish this block.
Yes, sir. I'll call her right now.
You are not telling me that you're not calling her, are you? Court calls the case People versus Jennifer Nielsen.
Good afternoon, Your Honor.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Jennifer Nielsen, who might be on Zoom. Okay, then I do not know where Miss Nielsen is, Your Honor, and for the record, I will be requesting an adjournment.
Okay. Bench warrant will issue for defendant's failure to appear bonds at 10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Court calls the case People versus Brent Pearson.
Good afternoon, Your Honor. Raymond Cook.
Joy Gaines, Senior Assistant Public Defender, representing person. State your name for the record.
Brent Person, Your Honor.
Thank you, sir.
Your Honor, you should have a green sheet. We are requesting an adjournment for this matter.
Probable cause conference, May 14th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Francisco Quezada Larreta.
Public Defender, Shanazi Carey, I can really, Your Honor, on behalf of Mr. Quezada Loretta. Francisco, state your name for the record.
You're muted, sir.
My name is Francisco Cozar Loretta. I'm sorry about
All
that,
right.
Your Honor.
It's okay. You're requesting an adjournment.
We are, Judge. We finalized everything. The people have sent over the forms, but we decided that we should do a no contest plea. So we just need to get the information to the court.
Okay, so you can do it in a week. I'll adjourn it to April 30th,
Thank you, Judge.
2026. Court calls case, the people versus Kristen Reed.
People?
Public Defender Duffy Lee on behalf of Mr. Reed, who appeared. Actually, no, he appears in person. Mr. Reed, could you tell the judge your name, please?
Kristen Reed.
Your Honor, we're requesting a green in order to receive and review some discovery.
Probable cause conference, May 14th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Have a good afternoon.
Here. Court calls case people versus Antonio Richardson.
Good afternoon, Your Honor. Raymond Cook for the people.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of,
On your phone because you're calling?
Judge, I'm trying to step out, but
Okay, go
all
ahead.
my cases. Judge, on behalf of Mr. Richardson, Your Honor, our office received an email this morning from the Detroit the detention center. And it seems as if Mr. Richardson turned himself in on a bench warrant. He informed them that he had court today. We were trying to see if we could get him on Zoom, but they said by the time they transfer him from where he turned himself in to where they'll be holding him, they won't be able to get him on Zoom. So I'd like to ask for an adjournment at least 2 weeks, and then maybe we can writ him out. I don't know how long he's going to be there. It was an email directly from someone from Detroit, like a state email address. Trying to find it.
What, that they just sent to you?
Yes, Judge, they sent it to our clerk's department, our legal assistance department, and then they forwarded it to me because he was assigned
How
to
did
work.
you know to do that?
The client told them who was representing him and that he had court today in Washtenaw County. Mm-hmm.
What?
What?
Who?
At Detroit 313.
I don't believe that's how it happened at all. I don't. That story is like neatly. I don't even think you got an email.
Judge.
And I think, you know who sent that email?
The client.
Cannon.
My God. So Judge, that's all I've got. I don't know how long, obviously we weren't able to speak with him when he was there. I don't know how
Why
long.
did he go turn himself in there if he knew he had court here?
No.
I know. I asked it. It's a
He
good.
missed the mark, Judge. He should have came here first. Then went there.
Okay, I'll tell you what I'll do. Bench warrant will issue. Nice story.
Okay, Judge.
But the amount of 10,000 cash surety. But so you can get everything together, I won't issue a warrant until April 28th.
Perfect. Thank you, Judge.
The last nice thing for this month. Court calls case, people versus Destiny Sherlock.
Good afternoon, Your Honor. Raymond.
Good afternoon, Your Honor. Assistant Public Defender Alexis Serp standing in for Mr. Bellinger on behalf of Ms. Sherlock, who I believe is appearing on Zoom.
Yes, there she is. Ms. Sherlock, can you state your name?
Destiny Sherlock.
Thank you.
Honor, you should be in receipt of a green sheet. I'd ask for a little bit of a lengthier adjournment on this one. My understanding is an additional discovery from a bank that's involved on this matter, and they indicated we would get that around the week of Memorial Day. So perhaps we could go past May 25th.
How come Bellinger's not here to ask?
He had some other matters to attend to and asked if I would. And asked if I would step in since I had already had my own case.
She knows I might yell and say no. Just put you there. Like I tell him no.
I understand.
He's somewhere with Cannon.
Mr. Feaster also thought Jay might be with
That's
Shannon as well.
exactly. See? Something's going on here. There's some conspiracy.
We're dropping like flies, Your Honor.
Let the head of your office know that. Say you. Oh, all right. But the information isn't coming into the week of Memorial.
Right, which is May 25th, Your Honor. So perhaps the week after that.
That's
So I
long and
believe is June 4th.
Oh, I know. I see it on my calendar. Thank you, though. Any objection from the people?
No, Your Honor.
Of course not. Right?
I'm trying to be a team player.
So nice. Kills me. June 4th, 2026, in bond continue.
Thank you, Your Honor.
Thank you.
Who? You should have said it was Feaster. Clerk calls the case, People versus Laura Smith.
Torsional Feaster, Assistant Public Defender on behalf of Ms. Smith, I believe is on Zoom. Please unmute, state your name for the record.
Laura Smith.
Thank you. You're receiving the green sheet.
Of course.
Yes, Judge.
And I promise.
Thank you. Well, we are requesting a brief adjournment, Your Honor.
Can you get everything done by the 7th?
Actually, we should be able to adjourn.
May 7th, 2026, 9 a.m. Bond will continue. Right. Thank you, Ms. Smith.
Thank you.
Court calls case, People versus Anthony Stoddard.
Raymond Cook for the people.
Assistant Public Defender with and on behalf of Mr. Stoddard, who should be appearing by Zoom. Would you please state your name for the record?
He's there.
Good morning, Your Honor. Good afternoon. Anthony Lee Stoddard.
Okay, good afternoon, sir.
Your Honor, we are in the process of negotiation, provided some mitigating information to the prosecutor to consider. We're asking for a brief adjournment.
May 7th, 2026, 9 a.m. Bond continue.
Thank you.
Court calls case, People versus Nathaniel Tanner.
Ready again, Judge. Torsional Feaster, Public Defender on behalf of Mr. Nathaniel.
Here,
Tanner.
Judge.
Oh, he was here. State your name for the record, sir.
Nathaniel Tanner.
Thank you, sir.
You should be receiving a green sheet. We are working to try to move this matter forward, but we are requesting a brief adjournment.
Turn the matter to May 14th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case of the People versus Jeffrey Thompson.
Helps with people.
Assistant Public Defender. Here. Oh, excellent.
I knew he was there. Hello, Mr. Thompson. How are you?
So, Your Honor, I apologize. We were unable to reach Mr. Thompson by phone and I did not see him come in. Mr. Thompson, no, that's okay. That's my problem. You're here, so you did all the right things. So we were able, Mr. Thompson was accepted to mental health treatment court.
Okay.
We had already been worked out. I do have the plea form and I believe Miss. Did she go over the plea form with you?
Yeah.
Okay, so if he could have an opportunity to sign the plea form, he had an opportunity, he has gone over it with Miss McGee and potentially, yes, Miss Casey McGee. It is going to be a guilty plea, is that correct?
Yeah.
And
Okay.
perhaps we could
Before we go on,
forward or
Thompson.
so.
Gotten a Have you got to speak with the lawyers? Or no?
Yes, he did get to speak with Ms. McGee just a moment ago, he said. Oh, you just located it. So,
Okay, so you haven't gotten to talk to anybody yet.
so you,
Okay, let me,
okay,
Sorry, I'm.
Both together.
Then-
I'll be-
then-
look at everything. It's a.
well,
I think he was aware that this was coming, so we have a few moments to go over the plea form and the paperwork with him.
what I'll do is I'll pass it and. All right, would that work for you think?
Okay.
Thompson?
Well, you'll have a chance to talk.
Oh, yeah, yeah.
Okay, so, and they'll be very good about answering all your questions and everything. All right, and if there's something you don't understand, just tell them. If you get to the end of the whole talk with them and you just think you need more time, don't be afraid to ask. I'll give you some more time to, like, if you need another week or so to think about it, I don't have a problem doing that either. Okay, but let's see if we can get through some of this.
Okay.
Okay, are you still living at the same place you were?
Until the 31st of
Until when?
next month, the 31st. I don't know what I'm gonna do, but well,
He said until the 31st of next month.
hey, yeah,
You know where you're going?
no.
Is somebody working with you on that? No?
No, I tried to go to Ann Arbor Housing Commission last week, but just told me to go online and try and submit an application for their wait list. So I'm trying to work on it, but
Pardon me?
actually feel a little better like the last couple of days than what I have the last several months. And maybe it's saying too much, but I met somebody yesterday who through their office that, you just meet people that change perspective. And
Okay.
she made me feel okay. I felt better leaving their office yesterday than what I have in a long time. And I think she knew it was, she just knew. Yeah.
All right.
It sounds, yeah, I don't know. Sometimes I don't, I just.
Sometimes those kind of events are hard to explain. Okay, so why don't you go ahead and talk with your attorneys and we'll see where you are, okay? All right, thank you.
Sorry.
Okay. Court calls case People versus Jamie Tokarski.
And good afternoon, Your Honor, Assistant Public Defender Alexis Search on behalf of Mr. Can you please unmute and state your name for the record?
Jamie Tokarski.
Your Honor, we're requesting a adjournment to continue plea discussions with the people.
During the matter to May 14, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you.
You're welcome, ma'am. Court calls case People versus Kenneth Tucker.
For the judge, Torshell Feaster, Assistant Public Defender on behalf of Kenneth Tucker, but not with Mr. Kenneth Tucker. I have already spoke to Mr. Cook about it, and he knows what I'm asking for an adjournment. I have received a text message from the highest levels of the Public Defender's Office where apparently they've spoken to Mr. Tucker, and he indicated that he's having ride problems. His ride did not show.
What?
I can read your text, but essentially it says he's having a ride problem. His ride did not show up to pick him up, and that not sure he's going to be able to make it today, and he's panicking about missing court.
Where does he live?
That I do not know.
Oh, he's over in Belleville, San Janaza.
Okay. We could try that.
Said he didn't have a ride?
Yes, Judge. That is what I received from my higher ups. And I can show it to you if you don't.
No, I don't.
So I was told to request an adjournment and let them report back as to whether or not he got it, so they can tell him what he needs to do.
April 30th. Got 1 week. So if he can't figure out the right, start hoofing it,
He'll get here by then. Thank you, Judge. I will send the text back.
court calls case versus Marius Warren.
Your Honor. And good afternoon, Your Honor. Assistant Public Defender Alexis Serp standing in for Mr. Bellinger on behalf of Mr. Warren, who's approaching. State your full name for the record.
Good afternoon, Your Honor. Maurice Moore.
Your Honor, you should be in receipt of a green form. I believe we're just adjourning to continue plea negotiate the people.
Not objection, May 14th,
Thank you, Your Honor.
26, 9 a.m. Bond continued. Thank you. Clerk calls the case people versus David Wilhelmi.
Good afternoon, Your Honor. Raymond Cook for the people.
And good afternoon, Your Honor. Assistant Public Defender Alexis Serps with and on behalf of Mr. Wilhelmi, who is present on Zoom. Can you please state your name for the record?
David Wilhelmi.
Your Honor, we're requesting an adjournment. There's some videos that Mr. Cook has marked to be sent over to my office, so we should be in receipt in those very soon and to continue negotiations with the people as well.
Just to clarify this slightly, the officer had the videos uploaded under the wrong case number. He's re-uploading them under the proper case number to share them with us. Once I get that, then they'll be sent.
Then they'll be sent over. Okay. May 14th, 2026.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Court calls case people versus Calvin Williams.
Good afternoon, Your Honor. Raymond.
Assistant Public Defender, I'll be here. I can really, Your Honor, but Your Honor, not with Mr. Williams. I think we had contact with Mr. Williams.
Have what?
We had contact with Mr. Williams. I've asked someone to call his phone again, but unfortunately, I cannot or do not have an explanation for.
Tell him to call.
I did. I did, Your Honor.
So what happened?
He is apparently at the University of Michigan Hospital, and you should grant him an adjournment today.
Please.
Please, Your Honor.
Wow.
We can get proof over to the court if the court would give us some time, but before we did not know why he wasn't here, but we spoke with him previously.
Getting there. Why did he ask me for that?
Why? Because he knew that's what I was gonna ask for, Judge.
No, you wouldn't have been that bold.
I'm shy. Oh, Judge.
May 7th.
Thank you, Your Honor.
Don't thank me, thank him.
All right.
9 a.m. Bond continued. I'll need proof that he was in the hospital. Court does call the case. People of the State of Michigan versus William Workman Jr.
People, I can really, Your Honor, on behalf of Mr. William Workman, who is approaching the bench. Mr. Workman, state your name for the record, please.
William Workman.
Judge, you're asking for an adjournment.
Oh, that was Mr. Workman?
I did.
What? No, did you?
He was sitting there. Like,
No, did
no,
you?
that was him.
That was him.
I did, Judge. Yes, I did.
Then like,
That was you.
just turned around, she stared at him like, I hope it's you.
I turned around like, get up here. Yes.
All right, but
Yes. Judge, we made contact with him today. We have reviewed some things with him, but obviously we need a little bit more time.
okay.
Did you give him your number?
May 14, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
I'll write it down for you. Okay.
Court calls case people versus, is it Yilin Yang?
Senior Assistant Public Defender, representative is available by Zoom.
Sir, would you state your name?
Yilin Yang.
Ellen, okay, all right. You're asking for an adjournment.
Yes, Your Honor.
What you are. But it's May 14th,
Thank you so much.
2026, 9 a.m.
Thank you.
Thank you, Your Honor.
You're welcome, sir.
Thank you, Mr. Yang. Yes, to recall.
Yeah. Court's gonna stand in brief recess. No, thank you. No, I just did that. So I was seeing if you were paying attention. No, everybody have a seat. They need the prosecutor's signature.
Oh, I apologize.
It's okay.
So focus-
Oh, it's okay.
Okay, I was so focused on Mr. Thompson. Okay.
All right, yeah.
Yes.
See it? Sure, what did you give me?
I tried to get rid of it.
Okay. For recalls case, people did it. It's Jeffrey Thompson.
Joy Gain, Senior Assistant Public Defender, with and on behalf of Mr. Thompson.
State your name.
Jeffrey Thompson.
All right. I have before me a plea form that indicates that defendant is going to be pleading. Are you doing no contest or guilty?
We're doing, I believe, a guilty plea. Is that correct, Mr.?
Has to plead guilty. He's going to plead guilty to the charge of malicious destruction of personal property, 200 to 1,000. The 1 year offense. Upon a successful plea to that count 2, count 1 would be dismissed. There's also an agreement that the defendant agrees that he will be entering the mental health treatment court in the 15th district court. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
Okay, so I need on this form, Ms. Gaines, you sign where the defendant, I need the defendant's signature, just that.
Yes. I was,
Signed on his line.
I signed on this line, so that,
Okay,
so that, no, you don't, you're not sorry. I'm sorry, because I signed where you're supposed to sign. But if you'll sign here. Okay. When you came in, I was so excited. that You were here.
So, there you go. Thank you.
all right, everybody did say that's the agreement.
Yes, Your Honor.
Yes, Your Honor.
May I have the defendant's warrant?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self.
Yes.
State your name, please.
Jeffrey Thompson.
All right, Mr. Thompson, this is court's understanding that you're going to be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000.
Yes.
All right, that's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The court fine could be increased to 3 times the value of the property otherwise destroyed. That's greater than $2,000. That becomes the maximum fine. Okay.
Yes.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court.
Okay.
Understand that?
Yep.
Okay. Understanding all of that, you still wish to plead guilty.
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you're not going to have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
Don't think so. Thank you, though.
Okay. I need you to look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes, sir.
and of your own free will,
Yes,
because you believe that you're indeed guilty of this offense?
yes.
All right. December 21st, 2024, North Main Street, Front Street in the city of Ann Arbor, Washtenaw County, state of Michigan. Let's do it this way. You know what you did on that day?
Not really.
Do you know what happened with the police?
Yes, yes.
Do you know what happened with the police or fire department on that day at
Yes,
Main Street in Huron?
yes.
Okay, would you tell us?
I was scared trying to get to the hospital and I didn't know where I was at, so I was in the car.
And do you recall what happened with the car in terms of any damage?
Yes, I accidentally hit the window.
You hit the window of was it a police vehicle?
Yes,
Was the window damaged?
yes.
So
And you knew it was a police vehicle at the time?
Yeah, yes, yes.
Yes, you did.
I don't,
Okay, hold on. Did you know?
I really didn't.
Okay, let me ask you this, and we might have to do something else, Mr. Thompson, but it's not your fault, okay? I'll put it this way, you were at this time, and I know that I may know this because of other cases that we've had. Were you having issues with your medication?
Yes, well, very much so.
And when you were having those issues with your medication, you weren't, while you were acting voluntarily and doing that, you weren't sure necessarily what you were doing. Is that right?
No, it was a bad time.
Okay. So here's what I'm gonna do. I'm gonna stop the plea. The date we have is the 28th for sentencing, but my next date is the 30th. So let's see if we can get another sentencing date
Okay.
for him. And I'm just gonna put it out 1 week and we're gonna make it, they're gonna tell you what a no contest plea is, okay?
Okay,
And that way, if you're comfortable with it, I'll just read the report and then make a determination from there,
okay.
okay?
Thanks.
Because I know you're trying to,
Yeah.
okay, I know you're trying, but I just gotta make sure that, the right thing is happening,
Okay,
okay?
thank you.
Fair enough?
I trust you.
Okay, thank you for that. That means the world to me, Mr. Thompson. All right, so I will adjourn this matter out then to April 30th, 2026 at 9 a.m. or as your invite indicates. Okay, but we gave it a shot. We just couldn't get it done. Okay,
Okay,
That's
thanks.
okay.
Simpson.
you're welcome. We'll see you next week.
All right, thank you, Your Honor. Thank you, everyone, for your patience. I appreciate it, and I know Mr.
Yeah,
Johnson does
thank you.
as
Thank you.
well. It means a lot.
Very good.
Get a report in
A
too.
lot, right?
Thank you. I
Yeah.
really appreciate it.
Oh. You can talk about it a different day.
Bird stands in wreath.